All right, good morning, ladies and gentlemen. My name is Judge Law, and we're going to begin with our state all-purpose calendar with the State Court of Fulton County for today, March 27th. These are calendars involving misdemeanor cases which have already been formally accused by the Solicitor General of Fulton County. We are going to determine the status of the cases today. It is essentially a plea and arraignment calendar where the defendants, after conferring with their attorneys, will determine whether they would like to accept a plea offer from the prosecution or whether they would like to enter a not guilty plea and have the case further reset for trial. If you are a defendant accused of one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. But I hope most of the folks who currently have cases against them have already had an opportunity to speak with counsel, whether retained or appointed. Okay, courtroom 2, who are we addressing first?
Position number 33, Mr. McCray.
Good morning.
Good morning. And Louis Irvin McCray, position 33. His case number is 25 CR 001354J. Mr. McCray, you've been accused of battery from March 14th, 2025. You've been advised of your rights, and your attorney at the present time is going to be Mr. Tom White. Mr. White, how are we proceeding? I don't have a list of announcements, so I'm going to have to be bugging you guys. Please unmute.
It's a negotiated plea, Your Honor.
Okay. Oh, it looked like Mr. Chate sent in an announcement. Do you have it?
I don't have it.
Okay.
I'm not sure when he sent it. But
Okay.
I'm sending it your way, Judge Law. Do you want me to also send that to Mr. Jordan?
Yeah, just send it to Mr. Jordan. That'd be great. Thank you.
Okay.
Okay, so this is going to be a plea hearing. Mr. McCray, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Smell.
Thank you. Ms. Falk, good morning, and the recommendation?
Your Honor, on this case, the state's recommendation is 12 months served 28 days, credit for time served 14 days, from March 14th to March 27th of 2025, balance probated, ADET, 12 weeks of anger management, 40 hours of community service, no further contact with Joshana Crew, and stay away from 3200 Cushman Circle in Atlanta, Georgia. We did have an opportunity to speak with Miss Crew. She stated that they are siblings. They do not live together. She stated that he held her and struck her several times in the bathroom of the home, that she sustained 2 black eyes, and that they live in the same complex but stay in different buildings. She stated she agrees with the plea, and she also stated she will be here on Zoom today. So we would like to sound from Miss Joshana Crew. We do also ask the defense stipulate to venue factual basis and identification for the purposes of this plea.
All right. Ms. Crew, are you, if you're present and like to contribute, you would need to unmute and start your video. All right, Mr. White, do you so stipulate?
We do, Your Honor. We just ask that you waive 3 months of probation fees so that he can apply that to his anger management class, and ask that the probation terminate upon completion of all of his terms.
I will waive probation fees from now through, let me see, it's March, April, May, through the end of May, and he'll start paying probation fees from June 1st, 2025. Mr. McCray, have you consumed any medicine or alcohol?
No, ma'am.
Have you, sorry, go ahead.
No, ma'am. I'm listening.
And have you understood what's going on in your case?
Yes, ma'am.
Are you,
I was wondering, could I be appointed for more than just anger management? Because I'm.
Mr. McCray, we talked about this yesterday.
All right, I got
Yeah.
you.
All right.
if you don't want to do anger management, you can enter.
Judge,
All right.
he wants the anger management.
I see.
Right.
Okay. Then in that case, let me proceed. Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
And so hopefully it's been explained to you that if you enter a guilty plea to this charge, you would have to give up your right to a trial. You will not go back to court to face a jury or the judge. You will not get a chance to confront your accuser, challenge the evidence brought against you, be able to present your defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to one count of battery?
Nolo?
All right, I don't believe a NOLA was on the table,
Oh,
so,
whatever my lawyer, he presented.
all right, stop. Okay, Mr. White, proceed. What do you want to say?
Judge, if he was eligible for a NOLO, then we'd ask for a NOLO since that's what he wants to do. If not, we would just go forward with a guilty plea.
Guilty, I take guilty. I take guilty. I don't know.
Your
Mr.
Honor,
McCray-
I'll make this easy. The state objects to a NOLO. He did say he wishes to proceed with a guilty plea if you did not accept a NOLO. And we do object based on his history.
And just to point out that the state's objection and your decision aren't necessarily the same thing, Judge.
So noted.
Understand.
Mr. McCray, based on the plea recommendation, the agreement was for a guilty plea. But if you want to plead NOLO, then I will disregard the plea and reset the case for trial. How would you like to plead to the one count of battery today?
Guilty, man.
Your sentence will be 12 months to serve 28 days, credit for time served 14 days. If you have no other cases holding you at the jail, you should be released within 24 hours. But on Monday, which is going to be, I think, March 31st, the last day of March, you will have to report to Fulton County Probation Office at 132 Mitchell Street in downtown Atlanta. You must report to the office before 3 p.m. While you're on probation, you will complete an alcohol and drug evaluation and submit yourself to any treatment, counseling, or medication that's required. You must undertake the evaluation within 15 days of being released. So by the middle of April, you should have done the evaluation. You're also to enroll in anger management classes, and you must enroll in those classes within 60 days of being released. You will complete all 12 anger management classes without missing or skipping any of them, and those shall be paid out of your own pocket. You're also to complete 40 hours of voluntary community service at any nonprofit agency. The agency cannot be a church and it cannot be a school. You must complete the 40 hours at a minimum rate of 5 hours per month. At all times, you are to stay away from 3200 Cushman Circle in Atlanta, Georgia, and have no contact with Jashana Crew. You can stay in the same apartment complex, but when she's outside her building, you must return into your apartment, or if she's outside the building, you must vacate the complex. In other words, you cannot be outdoors when she is. Do you understand? And you're not to communicate with any way, form, or manner. That completes your sentence. Please report to probation on Monday before 3. Thank you.
Thank you, Your Honor.
Oh, I did indicate his probation fees are waived up to and including the end of May 2025. He starts paying probation fees from June 1st. Thank you.
I won't make it on the 1st. I have a hold, so I won't make it for probation on the 1st, so you guys won't put a fade to appear or anything. I gotta wait for East Point to come and get me.
All right, Mr. White, does your client have a hold?
He does, Judge. So
All right, then he will report to probation within 48 hours of being released from any of his holds. So once you're released, you must report to probation within 48 hours on the first available Monday, Tuesday, or Thursday.
Yes, ma'am.
Thank you.
All right.
Calendar, Lana White. I said to resend them to not bring in, but it could be actually.
All right, I have Attorney Stewart and Attorney Rainwater on Zoom. Y'all just have to wait until the deputies in the jail produce your clients on the Zoom. I don't have a way to modify that queue. Okay?
You Judge.
That's fine. All right.
Next, Your Honor, is position number 27 and 28, Mr. Long.
Okay. This is Rodriguez Long. Mr. Long has two matters before the court. 24 CR 3101Y, in which he's accused of theft by shoplifting, giving false information to a law enforcement officer, and willful obstruction of an officer. The second matter is a bench warrant, 25 FTA 586. Mr. Long, you've been advised of your rights. Your attorney is going to be Mr. White. And with regards to 27 and 28, this is going to be a plea. Mr. Long, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Yes.
All right.
And if we need to litigate it, we'll just reset.
And Ms. Falk, what's the recommendation for Mr. Long?
Yes, Your Honor. On position 27, the state's recommendation on the theft by shoplifting count 1 is 12 months served 24 days. Credit for time served 12 days. That's going to be from May 19th to May 22nd, 2024, March 20th to March 27th, 2025. Balance probated in anti-theft course. Stay away from the Walmart located at 6149 Old National Highway in South Fulton. 40 hours of community service. On count 2, the giving false information to a law enforcement officer, 12 months concurrent with count 1. And count 3, willful obstruction of a law enforcement officer, 12 months concurrent to count 1 and a $300 fine. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. That's all for the state. And on position 28, Your Honor, we will be entering a null pros upon the acceptance of this plea.
Giving me credit for
Mr. White, do you so stipulate?
over 30 seconds.
Yes, Your Honor, we stipulate. We just asked that the $300 fine be converted to 30 hours of community service and this probation terminate upon completion.
Yeah, I don't understand.
Any
that.
objection to
We don't ob-
conversion?
We don't object to non-reporting, Your Honor.
Okay. Any objection to the conversion?
No.
All right. Which means then your client has to do 70 hours of community service. Is that what your client's willing to do?
Yes, Your Honor, we discussed it yesterday.
Okay. Mr. Rodriguez Long, have you consumed any medicine or alcohol recently?
No. Never stayed for that.
That's it.
I'm sorry, could you look up, please, and speak up a little clearer?
No.
And have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained to you that if you decide to plead guilty to the 3 charges brought against you, you would have to give up your right to a trial in front of a judge or a jury? You will not get the chance to go back to a courtroom to face your accuser, challenge the evidence brought against you, present your own legal arguments and defenses, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
And Mr. Long, has it been explained to you that if you have 3 or more convictions for theft by shoplifting, any future arrest for the same offense will be a felony charge?
Yes, ma'am.
How do you plead to 1 count of theft by shoplifting, giving false information to an officer, and willful obstruction of an officer? Mr. Long, how do you plead to the 3 charges I just listed?
Guilty.
What you were saying about the,
For theft by shoplifting, your sentence is 12 months to serve 24 days. Credit for time served 12 days. If you have no other holds, you'll be released within 24 hours to report to probation on Monday, March 31st, before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete an anti-theft class, and you must enroll in that class within 60 days of being released. At all times, you are to stay away from the Walmart at 6149 Old National Highway in South Fulton, Georgia. For the theft by shoplifting, you'll be required to do 40 hours of voluntary community service. The false information charge will be 12 months probation concurrent with count 1. For the willful obstruction, it will be 12 months probation concurrent with 12 months with an additional 30 hours of voluntary community service. In total, you will have 70 hours of community service to complete, and you will do that at any nonprofit agency or agencies, and they cannot be a church and they cannot be a school. You will complete your community service at a minimum rate of 10 hours per month until all 70 hours are completed.
Yes,
I will waive your probation fees until the end of May 2025, and then you will start paying probation fees from June 1st, 2025 onwards. That concludes your sentence.
Thank you, Your Honor.
You haven't seen it.
Oh, and the bench warrant will be null prost.
but if I'm gonna be sitting here that long anyway, if I wait to go to trial, so I might as well just go.
Courtroom 2, if you're all having discussions between a defendant and counsel, we can hear you, so just FYI. Okay. ACDC, you unmuted. Are we ready to go, Deputy Francois? Good morning.
Yes, good morning, Judge. I have position number 4, Bussy.
Okay, this announcement is for the individuals at ACDC. My name is Judge Lal. We're going to be addressing each of your cases on a one-on-one basis. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and if you cannot afford one, one will be appointed to represent you today. Ms. Tesra Bussy, case 25 CR 1351J, is accused of driving while license suspended or revoked, giving false information to an officer, and an expired tag. Ms. Bussy, you've been advised of your rights, and your attorney is Mr. Chate. Do you see him in courtroom 2?
Yes.
All right. And Mr. Chate is, I know I've got my checklist now, and that's going to be a plea. All right.
Yes, just a negotiated plea.
Ms. Bussy, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk, what's the recommendation?
State's recommendation on the driving while license suspended is 12 months, served 26 days, credit for time served 13 days. That is from March 15th, 2025 until today. Balance probated, a $500 fine. Count 2, 12 months concurrent with count 1. Count 3, 12 months concurrent with count 1 and a $135 fine. We do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. We do not object to the defendant going non-report after the completion of paying their fines.
All right. Mr. Chate, does your client still have a hold from a Superior Court matter?
Yes, Judge, I see a hold from East Point.
No, I'm not.
All right. Okay. Sorry, do you stipulate to the factual basis, venue, and ID, sir?
Yes, Judge, I stipulated and I was just going to ask to put her on non-reporting once she pays the fine.
Yeah, that'll be fine. Ms. Bussy, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes. That I'll be on probation for 12 months.
Yes, but only once you're released because you have other matters holding you at the jail.
Yes, and that's for East Point. Is that correct, Judge?
I understand that you've got a case in the Superior Court of Fulton County.
Oh, I wasn't aware of that, but
Would you like to speak to your attorney?
yes.
All right, we need to place court, Mr. Chate, they'll need to call you from ACDC.
Okay, all right.
Right.
The phone is actually being used. I'm not sure, how they're gonna call.
Okay,
We can
All
just
right.
do a breakout, Judge. Judge, we can just do a breakout.
I need courtroom 2 for other cases. All right. ACDC, please mute. Courtroom 2, who do we have next?
Position number 29 through 30, Mr. Matthews.
Who represents Mr. Matthews?
I do, Judge.
All right, sir. And how are we proceeding, Mr. White?
Your Honor, we're asking for a bond hearing.
All right. Is there an arraignment been filed? Oh, I'm sorry, has a waiver of arraignment been filed?
Not yet, Judge. I mean, if we need to do that, we will, but
Okay. Well, let me see.
it's-
Looks like he's here on a bench warrant and it was
You're right.
scheduled. Yeah, it was arraigned. Okay, that's fine. Okay, Larry Matthews case, he's got two matters, 24 CR 3849E, in which he was accused of battery, family violence from June 15th, 2024. What's holding him at the jail appears to be a bench warrant, 25 FTA 588, from February 18th, 2025. Mr. Matthews, you've been advised of your rights, and your attorney is Mr. Tom White. So, yes, Mr. White?
Your Honor, we're just asking that the bench warrant be lifted. The address that they sent his final court or his last court date to was the wrong address. It was the actual address that he was ordered to stay away from at the time of his arrest. He appeared in court November 18th and again in December 20th. And then the next notice that for his court date on the 18th went to the improper address. That's not his fault. He didn't know anything about it. And again, he'd been in court 2 times before. So we're asking that the bench warrant be lifted. We do have the proper address, which my understanding is that the clerk's office has as well. But that's not where the last notice was sent.
Mr. Jordan, can you tell me where was the last notice sent?
Position 9,
Position 29?
20.
Yeah, looks like he was released on June 17th, 2024. I'm presuming since he was required to stay away from the Piedmont, 3601 Piedmont Road. Was that the
Yes.
residence from?
Yes, it was, and they told me to stay away. It's my master. Sorry about that. Sorry about that.
Yesterday, let me talk, okay?
Sorry about that.
And then on August 2nd, we had a bond surrender from pretrial. Apparently, he was,
No, Andrews. Because he has to.
I'm not sure what the surrender was for either not reporting or a new arrest. Then he was arraigned on August 16th. Got a couple of notices here. Was sent to Piedmont Road, apartment 1103.
Full funds paid, okay.
And that is the incorrect address, Judge.
I'm just wondering when was the address updated because the
He gave
defendant. When did he give it?
From day one, before he was even released from jail, he said this would be the address because he couldn't go back to that one. He gave them his mother's address, and I can give that to the court now.
All right. So I'm just wondering when it was updated at the jail because his booking information had the Piedmont Road. So when was it updated?
Before he left the jail, he explained that that would be the address.
Okay. Ms. Falk?
Your Honor, just this case that he's sitting on jail for. So he has a failure to appear on this case, and then it looks like his bond was surrendered by Second Chance Bail Bonds Company on a different case. So there's actually multiple things at play according to his information.
Oh, that's a discount, yeah, okay. We're trying to, yeah, we're talking about that.
So that's what I'm trying to sort out right now is which case they surrendered his bond on. It looks like that was
And that really is irrelevant at this point.
well, I don't think it's necessarily irrelevant that the bonding company surrendered his bond. I think that goes to the trust that they put in his returning to court, which is an element of the issue of bond in our case.
Battery, family violence from June 18th. Is this the case that we're dealing with? June 5th? Yeah, June 15th. So that's the case. and then he was arrested again on July 20th, 2024, and released on the surety bond. So he's got 2 battery family violence cases.
That is correct, Your Honor, which goes to the
Okay.
factors of whether he's a good risk for bond.
And it looks like
With all due
the,
respect, the Ayala factors.
I'm just trying to get the history of the case. I'm just trying to figure it out, Mr. White. Multiple cases does tend to complicate the matters.
Judge, if
Go
the-
ahead.
If the clerk's office did not send the notice to the proper address, Ayala factors doesn't matter. He had been returning to court. He made 2 court appearances prior to this. So
And the defense has not shown one shred of evidence that they didn't send the notice to the address that was given. I can't find any other address in the jail system or in the clerk system that indicates anything other than the Piedmont Road address. If you have some proof or documentation that he submitted a different address, then by all means provide that to the court. But right now, what I'm showing is that the only address he gave was an
Well-
address that kept coming back returned to sender.
So you're saying that he never received notice?
Because he gave an address that could not have
Oh.
notice sent to it. Yes, that
The
is
jail
what
or
I'm
the
saying.
clerk's office used that address because that was the address that he was arrested under. And he was clearly given a bond saying that he could not return to that address, which the state clerk's office was a part of, and knew that he couldn't go back there. So why would they send the notice there?
Because it is his
Stop,
responsibility to
stop.
update his address.
I'm sorry, this is not a Zoom conversation panel. I would love to have a debate, but this is not it. Okay.
I think that's.
Next question, only question I have is, Mr. White, you are alleging that your client updated his address soon after being released
No, Judge,
from-
not what I said. I said that before he left jail, he told them in court and at the jail what his new address would be. And I have that address for the court. We do not expect this to be a problem. I don't understand why this is,
Well, I just going to complete my question.
okay.
Is it your client's position that he updated the court with the Wilmer address after he was released from the second battery charge?
He gave them that address before he left jail, my understanding, before he was released on the June arrest. If it was the July arrest, it still was updated prior to this notice going out.
Okay. Anything else, Ms. Falk?
Your Honor, I would just ask that the court deny the lifting of this bench warrant.
And
Since
Judge,
no-
I-
If I may finish, PD White, since no credible evidence has been shown that he updated his address.
well, I would say that the judge just mentioned the address, which I had not mentioned up until this point. So they have the correct address somewhere because I hadn't given that address yet to the court.
No, we do have the Wilmer address in the current case, the 3849E. I just don't know when it was updated. That's the only big question I have. But your position is that he
June or
gave-
July at the latest.
Well, it was either anytime after June 18th, 2024, when he was required to stay away from Piedmont, or anytime after September 4th, 2024, when he was arrested on the second battery family violence case, or when the bench warrant was issued and he was arrested on the bench warrant on March 20th, 2025. So I'm a little perplexed as to which particular date he gave us the Wilmer address. And based
Those
upon,
many times it's prior to the notice going out.
okay, there's a 33% chance that he updated it at any of those events, and that's not sufficient. So the bond modification is denied.
Well, Judge, I can do that math for you. He hasn't done it since he's been in jail, so that's 1/3, and the other 2/3 are both before the notice went out. So that's 100%. It was updated prior.
I'm not persuaded, Mr. White. It could have been on any of those events. So, but
Two of
he,
two of
I'm
the-
done. I'm done. Thank you. That was a ruling of the court. Now, his case has been arraigned. He's scheduled for a jury trial. The date haven't been set by Judge Morrison yet.
Judge, we'd ask for a reset to next week.
No, he's going on to Judge Morrison's calendar now. His case has already been arraigned. It's out of SAP.
Well, it's not out of SAP. We're in SAP currently.
No.
Arraigned in Judge Morrison's court at one of his previous court appearances that he made. But
This case is not reset to another SAP calendar. It has been arraigned. The bond modification request has been denied, and the case is going on to Judge Morrison's trial calendar, and it will be scheduled accordingly. Now,
before we do that-
if you have an offer from the prosecution that you would like to discuss with your client, you're more than welcome to do so.
Yes, I will take
what I
the,
was going to do in the next week, Judge, because it is for time.
Are we resetting the case for him to take a plea?
We're resetting the case for him to possibly take a plea. If he
All right.
doesn't, then we'll waive it, or it won't even need to be waived because it already has been, and we'll just say jail jury.
or can I,
Request tonight is going to Judge Morrison's court.
Can I
All
talk
right.
to you today on the phone then?
Oh, that would be all right.
Oh, well,
Okay.
thank-
All right, so courtroom 2, if there's a way to reach out to Mr. White, his client, Mr. Matthews would like to speak with him. Thank you. Next case, please, AC/DC.
Judge, real quick, I have a quick announcement just to let the courts know. The power here at ACDC currently will be going out, so we won't have any power here. So I would like to quickly get everybody done here at ACDC so we can send them back to their locations.
What are we doing with Tessera Bussey, Mr. Chate?
He's gonna go ahead and proceed.
I'm sorry, Francois, repeat what you just said?
She's gonna go ahead and proceed.
All right, I'm just waiting for Mr. Chate to show up in the council's chair in courtroom 2.
He's currently talking to one of his clients, Your Honor.
He'll need to.
Judge,
Mr. Chate, I'm so sorry, but we'll need to proceed with AC/DC before, otherwise we'll have to reset your client's cases. They're having utilities difficulties. Deputy in courtroom 2, if you could please tell. Thank-
I'm meeting with the client right now. I did, it's my turn to be up, so
Mr. Chate, AC/DC is apparently has electricity problems. If we don't address them now, their cases will be reset.
all right, well, I still haven't had a chance to speak with my client here. I was supposed to talk to her.
today.
You don't need to,
She's declining any further conversation.
doesn't want to speak. Okay, give me just a moment.
All right.
See if we can.
And how many which cases do you have at AC? No, we're going to address Bussey. Who else are we addressing in AC/DC?
I also have Judge position number 26, Ladria Sasha, and also position 23, Javed Johnson, and he has a private attorney.
Okay, let's start with Ms. Bussey. We're going to resume with the plea recommendation. So Ms. Bussey, do you understand that you may not be released right away from this case?
Okay.
All right, so continuing with the plea hearing in 25 CR 001351J. Ms. Bussey, as I was explaining to you, that if you decide to accept the plea to guilty to these 3 charges, you would have to give up your right to a trial, to be able to confront your accuser, challenge the evidence brought against you in a court of law, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to driving while license suspended or revoked, giving false information to an officer, and an expired tag? Your sentence for the count 1 is 12 months to serve 26 days, credit for time served 13 days. Once you're released from your holds, you will report to probation within 48 hours, and you'll be required to pay a $500 fine at a minimum rate of $50 per month. For the false information to an officer is 12 months concurrent with count 1. An expired tag is 12 months concurrent with count 1 with an additional $135 fine. So your total fine is $635 plus your probation fees. You'll be paying your fine at a minimum rate of $50 per month until your fine is paid off. After your fines are paid off and you're up to date with your probation fees, your probation will then be non-reporting. At all times, you are not to operate a motor vehicle until you have a valid and current Class C driver's license, adequate insurance, and proper registration. If you get arrested again for a suspended revoked license or no insurance or no registration while you're on inactive probation, your probation can be revoked. Thank you. Okay. Well,
Next, Judge, I have position number 26, Ladria Sasha.
That's my case, Judge, and it's a negotiated plea.
non-negotiated, okay.
And no,
Sash,
negotiated plea.
negotiate, okay, thank you. Sasha Ladria is accused of criminal trespass, March 12, 2025, case 25 CR 1311E. Ms. Ladria, you've been advised of your rights, and your attorney is Mr. Chate. Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, thank you.
Ms. Falk?
Yes, Your Honor. On position 26, the criminal trespass, the state's recommendation is 12 months, serve 32 days, credit for time served 16 days. That's from March 12th, 2025 till today. Balance suspended, stay away from 230 Peachtree Street in Atlanta. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Mr. Chate, does your client accept the terms, and do you so stipulate?
He accepts them and I so stipulate.
Ms. Ladrea, have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, Your Honor.
And has it been explained to you that if you plead guilty to this charge, you will not get the chance for a jury or bench trial? You will not go back to court to face your accuser, challenge the evidence presented against you, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, Your Honor.
How do you plead to one count
Yes,
of
Your
criminal
Honor.
trespass? How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 32 days, credit for time served 16 days, balance suspended. Although your sentence is over, please do not return to 230 Peachtree Street, that entire building. If you return to that location, you can be arrested again. Thank you. And the next position is
And I'll be
23.
released.
You'll be released within 24 hours unless you have any other cases holding you.
Thank you.
Javid Johnson, case 19 CR 000077F, is accused of disorderly conduct and criminal trespass from December 28th, 2018. Mr. Johnson, you've been advised of your rights, and your attorney is going to be Miss Elizabeth Rainwater. How are we proceeding, Miss Rainwater?
Your Honor, this is going to be a negotiated plea, and I sent over that plea paperwork to Mr. Jordan.
Thank you. Ms. Falk, you may, oh, sorry, Mr. Johnson, please raise your right hand. Do you Mr. Javid Johnson, yeah. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no? Speak louder, yes or no?
Yes, ma'am.
Thank you. Ms. Falk?
Your Honor, after speaking to Ms. Rainwater, we have modified our recommendation slightly on position 23, the disorderly conduct. Count 1, 12 months served 64 days, credit for time served 32 days. That's going to be from February 24th to March 27th of this year. Balance suspended. Count 2, 12 months concurrent to count 1. Stay away from the Chevron at 1072 Cascade Avenue in Atlanta. The defendant does not live in Georgia, so we are making a special condition of his suspended sentence that he stay out of Fulton County. And that is all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Wow, Miss Rainwater, he's required to stay away from Fulton County. No more games at the arena, no Mercedes-Benz, you know.
Your Honor, I believe my client would still accept that and move forward with that plea. He's got some pretty extensive ties to Connecticut he's a paraprofessional there at a school. And
Okay.
we do so stipulate, Your Honor.
Mr. Johnson, have you consumed any medicine or alcohol?
Yeah.
You did consume medicine and alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
I am definitely satisfied, yes.
Has it been explained to you that if you plead guilty to these charges, you will have to give up your right to a trial in front of a judge or a jury? You will not be coming back to Fulton County in a court of law to face your accuser, challenge the evidence brought against you. Your attorney won't be able to present your defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of disorderly conduct and criminal trespass?
Guilty.
On the disorderly conduct, it's going to be 12 months to serve 64 days, credit for time served 32 days, balance suspended, to stay away from the Chevron at 1072 Cascade Avenue, as well as all of Fulton County, Georgia. How do you plead to, on the criminal trespass, it will be 12 months concurrent with count 1. That concludes your sentence. Thank you.
And Your Honor, that concludes my business. May I be excused?
Yes, thank you, Ms. Rainwater.
Thank you, Judge.
AC/DC, we good?
Yes, we're good. Thank you, Judge.
All right, lights are still on, but that's good. Okay.
It's gonna go out at 9:55.
Oh dear, okay. All right, courtroom 2, who do we have next?
Position number 2, Mr. Bates.
This is Emmanuel Brown, accused of loitering and prowling, misdemeanor possession of marijuana, and a PI charge.
Your Honor, this is position number 2, Mr. Bates.
Oh, 2, I'm so sorry. Oh, I skipped a page, I'm sorry about that. Let me revise what I just said. This is Toma Bates, is that correct?
Yes, Your Honor.
Yes.
Okay. Case number 25 CR 1314F, accused of 3 counts of simple battery against a police officer, a corrections officer, or detention officer. Mr. Bates, you've been advised of your rights, and your attorney will be Miss Maureen McLeod. Ms. McLeod, good morning. How are we proceeding?
Good morning, Your Honor. This is going to be a negotiated plea this morning. However, my client tells me that he believes that he has actually spent more days than the days that the state is saying. So I just want to make sure that the amount of time he spent has been correctly calculated.
All right, let's see now, Mr. Bates, Toma Bates, and this incident dates from February 8th, 2025. He was booked in on February 24th, 2025, and he has been in custody for 32 days. In addition to these charges, he also has got a probation violation matter. And the state is giving him to serve 90 days, credit for time served 17 days. All right, Ms. Falk?
Yes, Your Honor. I just needed to look at one thing really quickly. Okay. I was calculating from the date this warrant was taken out. So the warrant was taken out on this case on March 11th, 2025. The defendant was still in custody when he committed this offense, and the incident happened on March 11th, 2025. So I'm giving him the credit from the date of the incident of simple battery against police officers. I can't credit him for time before the crime occurred.
Okay, I'm a little perplexed. On the jailing screen, the incident date appears to be February 8th, 2025. The calendar is February 8th, 2025. But you're saying the incident date was later than that?
That is correct. If you'll look at the warrant, I know it says February 8th, but in the body of the warrant, it says on March 11th, 2025, Officer Braithwaite responded to a call at 254 Peachtree Street Southwest and spoke to the correctional officers. And then the date of the warrant, where it is signed by Officer Braithwaite, is also March 11th, 2025.
I was here. I was here.
Mr. Bates, you don't have to say anything. I will speak for you. I believe if the warrant is dated that day, then he should get credit for the time served. And he has actually been there. He's willing to take a plea, but we want to give him full credit for all that time that he has spent in jail. I just think it's appropriate.
I'm just confused, which is quite common, but let me see. The warrant I have is signed by Magistrate Catherine Kura on March 11th, 2025, where Officer Krista Braithwaite went before the judge. And at the top of it, it says that between February 8th, 2025 at 1:13 p.m. and February 8th, 2025 at 4 p.m. So the incident date is from February 8th.
And Your Honor, I just wanted to direct you to the body of the
Yes.
actual.
Understood.
Correct.
And Officer Braithwaite responded to the location on March 11, who spoke to two other correctional officers with regards to what happened at the jail. And so which one is it?
Your Honor,
Is it February 8th or is it March 11th? They reported it. So did the incident occur on February 8th and she investigated the matter on March 11th?
That is the way that is my understanding of it, Your Honor, and I just feel like my client should get credit for that. He's willing to accept the state's plea offer, he just wants the days calculated appropriately, so he gets the proper credit.
Do you have a police report or incident report from the jail, Ms. Falk?
I do, Your Honor. It also has that same conflicting information where it says, and also I want to point out, according to this, he was arrested February 24th. So I'm not sure how an incident could have happened on February 8th when he was arrested on February 24th. And this happened at the jail. So that's also a little confusing.
All right.
One argument that
Please pause. I'll give him credit for the 34 days. If that's a scrivener's error on the part of the officer who drafted that before the magistrate, that's on the officer. But I'll give him credit. He's got other fish to fry and he's not going to be leaving jail at the present time. So, Ms. McLeod, your client will be given credit for, what did I say? 32 days?
34 days.
34 days?
I said
Okay.
34 days, Your Honor.
Your Honor, he's only been confined for 32 days. So I'm just want to be very clear. The jail is
32, sorry.
The jail is going to calculate the time. They'll the way they calculate the time. So I don't want anybody to be frustrated if they calculate it differently.
Okay, so 32 days, we're fine with that. He is willing to accept the state's plea offer, Your Honor, and we're not asking for any other change in the terms of the plea.
All right. Other than the amendment to serve 90 days, credit for 32 days, are we ready to proceed?
We are, Your Honor.
Your
Ms.
Honor,
Falk?
the add-on case, is the defendant entering a plea to that or not?
Yes.
Looks like there's another case, 24 CR 8158A. And that would be, this would be from December 14th. And you're giving him credit for 26 days?
That is correct.
And we're good with that, Ms. McLeod?
Yes.
Okay. So, Mr. Bates, please raise your right hand. We are, just one second.
So, again, for the next one, we might need them, we might need them here, but,
You here?
Mr. Jordan was just showing me how the jail is going to be treating this discrepancy between the incident date and the booking date. But at the end of the day, Ms. McLeod, your client on case 25 CR 1314F will have to spend an additional 13 days
Yes.
before he's placed on probation. And for case 24 CR 8158A, that is 90 days minus 53. He will have to spend an additional 19 days. So in total, he'll have additional 19 days before he's released and placed on probation. Would you agree?
Yes, Your Honor, and he's fine with that. I did discuss it with him.
Ms. Falk, any comment?
None, Your Honor. I honestly don't know how they're going to calculate this. The jail will calculate it however they see fit.
Okay. So, but in either event, I do see that he has a probation hold as well. So,
That is correct, Your Honor. He's going to court on that tomorrow.
all right. So, as I was saying, we are addressing two cases that I have just mentioned. Mr. Bates, you've been advised of your rights. Your attorney is Ms. McLeod. Please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Now, go ahead, Ms. Falk.
Yes, Your Honor. On the 3 counts of simple battery on a police officer, count 1 is 12 months served, 90 days. Balance suspended. No further violent contact with Lieutenant P. Hall, M. Russ, and D. Harris. Counts 2 and 3 are also 90 days, and the credit for time served will be calculated by the jail. On the add-on battery 24 CR 008158A, it is 12 months served, 90 days, credit for time served 26 days. That's from December 14th, 2024 to January 8th, 2025. Balance probated, 12 weeks of anger management, no further contact with Leonia Owens. We would at this time like to sound for Miss Leonia Owens, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We
Ms.
do so
Owens?
stipulate.
Thank you. Ms. Owens, if you're on Zoom, this will be the time to unmute and start your video. Mr. Bates, have you consumed any medicine or alcohol recently?
No, ma'am.
All right. Now, you heard a lot of discussion about how much time you spend at the jail. Basically, if you decide to take this plea, you would have to spend an additional 19 days.
Yes, ma'am.
And if you have no other holds, then you'll be placed on probation.
Yes, ma'am.
Is that your understanding of your sentence?
Yes.
Okay. Other than that, do you otherwise have any other questions about your two cases?
No, ma'am.
Are you satisfied with your attorney? And has she explained to you that if you decide to plead guilty to these two cases, you would have to give up your right to a trial in front of a judge or a jury? You will not be able to go back to court to face your accuser, to be able to challenge the evidence brought against you, present your arguments and defenses, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 3 counts of simple battery against a police officer from February 8th, 2025 or thereabouts?
Yes.
How do you plead to 1 count of battery in case 24 CR 008158A?
Yes.
With regards to the simple battery against a police officer, your sentence is going to be 12 months to serve 90 days, credit for time served 32 days, balance suspended. You're to have no violent contact with any of the members of the Fulton County staff, including those working at the jail. Do you understand? Do you understand?
Yes, ma'am.
On the battery charge, your sentence is going to be 12 months to serve 90 days, credit for time served 26 days. You have 19 days to serve out before you report to probation. Once you've completed the 19 days, you will report to probation on the first available Monday, Tuesday, or Thursday. This will be, of course, subject to any other holds you have at the jail. Once released, don't forget to report to probation, and then you will enroll in a 12-week anger management program. You must enroll within 30 days of being released. At all times, you're to have no contact with Leonia Owens. You're to stay 200 yards away from her. You cannot live with her. You cannot talk to her, speak with her in person or through any kind of electronic device. And if you violate that condition, you could end up back in jail.
Yeah, can I say something? That was not Fulton County, that was ACDC officers. That wasn't Fulton County.
Mr. Betts, please don't say anything.
Okay.
If you have any violent contact with any law enforcement from whichever agency they represent on this entire planet, you'll be back in jail. Does that make it easier?
Yes, ma'am.
All right.
Okay.
Next case, please.
Next, Your Honor, we can go to position number 1, Mr. Barnes.
Mondrell Barnes is accused of criminal trespass from December 21st, 2024. His accusation number is 24 CR 8262G. Mr. Barnes, you've been advised of your rights and your attorney is Ms. McLeod. Ms. McLeod, how are we proceeding?
This is a negotiated plea this morning, Your Honor.
All right. Any discrepancy with the jail time?
No, Your Honor.
All right. Mr. Barnes, please raise your right hand for the plea. Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge? You need to say yes or no. Repeat.
Yes, ma'am.
Ms. Folk?
Yes, Your Honor. The state's recommendation is 12 months served 26 days, credit for time served 13 days. That's going to be from December 21st, 2024 to December 24th, 2024 and March 19th, 2025 until today. Balance suspended, stay away from 187 Maury Avenue. That's Moury in Atlanta, Georgia. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
We so stipulate, Your Honor.
Mr. Barnes, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea offer today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to go back to court to face your accuser, challenge the evidence brought against you, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up this right? Are you prepared to give up your rights?
Yes, ma'am.
How do you plead to one count of criminal trespass at 187 Maury Avenue?
Guilty.
His sentence is 12 months to serve 26 days, credit for time served 13 days, balance suspended. Stay away from that location, otherwise we get to do this all over again. Thank you.
Thank you, Your Honor.
Next case, yes, Mr. Barnes?
Yeah, I'll put you on the phone.
Okay.
Next, we can go to position number 36, Mr. Patterson.
Unique Patterson is accused with interference with custody from March 14th, 2025, 25 CR 1378J. Mr. Patterson, you've been advised of your rights and your attorney is Ms. McLeod. Ms. McLeod, how are we proceeding today?
Your Honor, there is not a plea offer on the table, but we would like to ask the court to give my client a bond, which he could actually make if the court is not inclined to give him a signature bond. He's just been sitting in jail. When he was first arrested, the state indicated that they were going to transfer his case up to Superior Court. That still has not happened. My client is not in a position to post bond. He has a $5,000 bond. He just can't make that bond.
All right. Ms. Falk?
Yes, Your Honor. The defendant's $5,000 cash bond was ordered on March 15th of 2025 by Your Honor. And that is because of the facts of this case involving a juvenile victim. I have reached out to the DA's office to examine this case more closely due to not only this offense, but the defendant's previous history, which includes similar charges of a similar nature. The state has not received a response yet, and so we are still in a holding pattern. We are asking for a 1-week reset. I will say the state does not often ask for resets, except for on cases where we are trying to communicate with the DA's office just because they need additional time to review.
Anything else, Ms. McLeod?
Your Honor, I would ask for at least a good bond as opposed to a cash bond. You know, my client's just sitting in jail. He's homeless. He just doesn't have any kind of means or the possible connections to post a $5,000 cash bond. Most people don't.
I have to respectfully disagree. But in either event, I was the one who reviewed this case. I was one who reviewed the allegations, and it's very alarming. And I was the one who propounded at first appearance. I'm very curious as to why this case is in state misdemeanor court when I'm highly certain that the district attorney's office should review it for possible felony charges. I'm going to reset the case 1 week, and if the state still is, if the DA's office declines or it still remains with state court, then I will consider a surety bond in lieu of the fact that we're going to proceed as a misdemeanor. Thank you.
Thank you, Your Honor. Mr. Patterson, do not say anything. You have a right to remain silent. Anything you say can be used against you. We do not want that. If you have any kind of questions, please call me. Just ask the deputy for my number. I am happy to address any concerns that you have.
So this is reset to April 3rd? Mhm.
We can go back to position number 29 and 30, Mr. Matthews.
All right. Yes, this is Larry Matthews on positions 29 and 30. Mr. White, how are we proceeding?
Your Honor, Mr. Matthews would like to enter the negotiated plea.
All right. We are resuming with cases 24 CR 3849E and 25 FTA 588. Mr. Matthews has been advised of his rights and and in light of this announcement, please raise your right hand, Mr. Matthews. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, Your Honor.
Thank you. Ms. Falk?
Yes, Your Honor. On Mr. Matthews' case, on the first charge, which is the family violence battery.
Yo.
Excuse me, just give me a moment. I was responding to something else. Family violence battery is 12 months served, 150 days. Credit for time served, 58 days. Balance probated, FVIP, 40 hours of community service. No further contact with Michaela Castile. Stay away from the Piedmont high-rise apartments located at 3601 Piedmont Road in Atlanta. On position number 30, the FTA, we are lifting that upon the acceptance of this plea by the court. We would like to sound for Ms. Michaela Castile, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Mr. White, do you so stipulate?
We do, Judge.
All right, and I understand that your client will be spending an additional 17 days before he's released unless he has any other holds to be placed on probation. Would that be correct?
That's correct, Judge, and he's aware of that.
Okay. Mr. Matthews, have you consumed any medicine or alcohol recently?
Yes, ma'am, I have. I'm on medication while in here. Yes, ma'am, Your Honor.
And even after consuming your medication, are you able to understand what's going on with your cases?
Just a little on the behalf, when I served the other days, I was just wondering, my body, didn't know. I was wondering.
Mr. Matthews,
Yes, sir.
listen to me
That's the
first.
judge, can I get the 2 for 1?
Listen to me for a
Got a
second.
job at Grubby Deli's, I'm playing.
Listen, Mr. Matthews,
Yes, sir.
listen for a second,
Okay.
and then if you're not satisfied with what I say, you can address the judge.
Okay.
As we discussed, the 2 for 1 is included, and you have the 17 days, okay, that you still have to do. And she wants to know, just because you're on medication doesn't mean you don't understand what's happening here today. Is that correct?
That's correct.
Okay.
All right.
Just answer the judge's questions, yes or no, please. If you have anything else, we can talk.
After consuming the medicine, Mr. Matthews, are you able to understand what's going on in your cases?
Yes, ma'am, Your Honor, through my attorney, Mr. White. Thank you, guys.
And were you able to understand your conversations with your attorney?
Yes, ma'am.
Are you satisfied with your attorney's services?
I am. I just want to know, when can I contact my my job owner to let her know I can return to work the 17 days I will be in here, let her know what day I will be released from today. That's all I was trying to figure out.
Okay.
We can get a number from you there at the jail, and I can contact your employer for you and let them know.
Okay, so what's going on today? Do I have to do the whole 17 days here?
Mr. Matthews, you understand that we've been over this many times. You have 7 actual days to do. You will be in 17 more days.
And not including the 7 days I was at rest.
Yes.
And, all right. And, Mr. Matthews, are you entering this guilty plea freely, willingly, and voluntarily?
Really willing and voluntarily by myself. Yes, ma'am, Your Honor.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury. You will not be able to challenge the evidence that will be brought against you in a court of law. You will not be able to confront your accusers. Your attorney will not be able to present your arguments and your defenses, and the prosecutor will not have to prove the charge against you beyond a reasonable doubt. These are your constitutional rights that you would have to give up if you decide to plead guilty to battery family violence. Are you prepared to give up these rights?
Ma'am, Mrs. Law.
I don't understand your response.
Yes, ma'am, Mrs. Law. Yes, ma'am. Yes, ma'am.
How do you plead to 1 count of battery family violence from June 15th, 2024?
Guilty.
Your sentence is going to be 12 months to serve 150 days, credit for time served 58 days. Based on the calculations we have, you have an additional 17 days. Your release date will be set by the sheriff of Fulton County, who manages the jail where you are currently in. Based on what I have, it appears that you will either be released on April 14th or April 15th. But that will be dependent upon the sheriff of Fulton County. Once you have completed your jail time, and if you have no other cases holding you at the jail, you will then report to probation within 48 hours of being released, and you must report on the first Monday, Tuesday, or Thursday, as I said, within 48 hours of being released. While you are on probation, you will complete a domestic violence intervention program, and you will enroll in that program within 30 days of being released. And you will attend and complete all 26 classes without missing or skipping any of them, and you will pay for those classes out of your own pocket. You'll also be required to do 40 hours of community service at any nonprofit agency, but it cannot be a church and it cannot be a school. You will do your community service at a minimum rate of 5 hours per month, beginning with the first month. At all times while you're on probation, you are to have no contact with Michaela Castile. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. You're to stay 200 yards away from the entire Piedmont high-rise apartment complex located at 3601 Piedmont Road in Atlanta, Georgia. You're not allowed to enter that entire complex, including the parking lot, the leasing office, or any of its private property. Your probation will continue until the remainder of your 12 months are completed, and you must be up to date with your probation fees. Thank you.
Thank you, Your Honor.
Next, Your Honor, we can go to position
The
number.
bench warrant will be null prost.
Next, we can go to position 7 and 8, Mr. Carter.
Joseph Carter is got two matters before the court, 20 CR 2692G, in which he's accused of battery, family violence from April 13th, 2020. And he's got a bench warrant from May 10th, 2024, under case 25 FTA 566. Mr. Carter, you've been advised of your rights. Your attorney is Mr. Chate, and this is going to be a negotiated plea. Mr. Carter, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes. Yep, yes.
Ms. Falk?
Yes, Your Honor. On the family violence battery, the state's recommendation is 12 months served 24 days, credit for time served 12 days, from April 13th to April 14th of 2020 and March 18th, 2025 until today. Balance probated, 40 hours of community service and no contact with Maya Rudison. We had an opportunity to speak with Ms. Rudison. She does agree with the plea. She stated that they have not had any recent contact, and she stated she will not be attending the Zoom this morning. However, we would like to sound for her in accordance with Marcy's law. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. And as part of Your Honors accepting the plea offer and sentence, we will null pros position 8. That's all for the state.
Thank you. Mr. Chate, do you stipulate to the factual basis, venue, and ID, and does your client accept the terms?
I so stipulate, Judge. My client accepts the terms, and I just ask that this go to non-reporting once he completes the requirements.
Ms. Falk?
Your Honor, one of the requirements is FVIP, which is going to take him at least 6 months. So the state doesn't have an objection to going non-reporting given the age of the case. It is a 2020 case.
All right. It'll be non-reporting once he completes the domestic violence intervention program, the 40 hours of voluntary community service, and he's up to date with all his probation fees. Is that acceptable, Mr. Chate?
That's acceptable, Judge. Thank you.
All right. Mr. Card, I'm sorry, Maya Rudison, are you on Zoom? This would be the time to unmute and start your video. All right, Mr. Carter, have you consumed any medicine or alcohol recently?
No,
And have you understood what's going on in your cases?
yes, Your Honor.
Are you satisfied with your legal services?
Yes, Your Honor.
Are you entering this plea freely, willingly, and knowingly?
Yes,
If you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be going back to a courtroom to face your accuser, challenge the evidence brought against you, have your arguments and defenses presented by your counsel, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to one count of battery, family violence?
guilty.
Repeat.
Guilty.
Sentence is 12 months to serve 24 days. Credit for time served, 12 days. The remainder of the time will be on probation. Unless you have any other holds, you will report to probation on Monday, March 31st, before 3 p.m. And while on probation, you will enroll in a domestic violence intervention program within 60 days of being released, and you will complete all 26 weekly classes at your expense without missing or skipping any classes. You will also do 40 hours of voluntary community service at any nonprofit agency that is not a church or a school, and you will complete the community service at a minimum rate of 5 hours per month. You are to have no contact with Maya Rudison, which means that you're required to stay 200 yards away from where she is physically located, her place of employment, where she stays, wherever she happens to be, and you're not to communicate with her in any way, form, or manner. Your probation will be non-reporting as long as your FVIP, your community service, and your probation fees are all up to date. Thank you.
Next, Your Honor, we can go to position number 17, Mr. Greg Butcher.
Mr. Carter's bench warrant will be null prost. Position 17. Okay. This is State versus Donald Gray or Donnell Gray, case number 25 CR 1343Y. Mr. Gray is accused of willful obstruction of an officer, criminal trespass, and theft by shoplifting from a December 17th, 2024 incident. Mr. Gray, you've been advised of your rights. Your attorney is Mr. Chate, and this is going to be a plea. Please raise your right hand, sir. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Folk?
Yes, Your Honor. State's recommendation on position 1, the willful obstruction, 12 months concurrent with count 2, $300 fine. The criminal trespass is going to be 12 months to serve 60 days, credit for time served 15 days from March 13th, 2025 until today, concurrent with count 3. And the theft by shoplifting will be 12 months served 60 days, credit for time served 15 days, balance probated, 40 hours of community service, anti-theft course, and stay away from all Walmart stores. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. That's all for the state.
Mr. Chate, do you so stipulate?
I so stipulate, Judge. I just ask that this court consider that my client go to non-reporting status once he meets the requirements, and my client also asks for community service instead of the $300 fine.
Oh, let me see. How many cycles? Let me see. He had a $3,000 surety on this matter. Okay,
Yes, 49 cycles, Your Honor. We would object to non-reporting.
Is denied, Mr. Chate. He needs to be reporting every month. And with regards to the $300 fine,
Your Honor, excuse me. My apologies. I was looking at a different case. Hold on. I don't want to misrepresent before the court. Let me go back to Mr. Gray's case. I was looking at Rashad Stevens' history.
or
This defendant has, let's see.
or if pretrial is available, I'll be glad to have them chime in. Ms. Washington? This is position 17, gray.
Yes, Your Honor, there are 47 arrest cycles.
That's good. Thank you.
You're
Yeah,
welcome.
same ruling. Mr. Chate, he'll need to report every month and he'll need to get a job and he'll need to pay that $300 fine.
That's acceptable, Judge.
Just in different lifestyle for the next 12 months. Okay. Would your client still like to move forward?
Yes, we're moving forward.
All right. Mr. Gray, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And if you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to go back to court to confront your accuser, challenge the evidence brought against you, and have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to willful obstruction of an officer, criminal trespass, and
Guilty.
theft by shoplifting?
Guilty.
On the willful obstruction is 12 months concurrent with count 3. And that would be a $300 fine that you would need to pay at a minimum rate of $30 per month. On count 2, it will be 12 months probation to serve 60 days, credit for time served 15 days, concurrent with count 1, which means that you have 15 more days to serve at the Fulton County Jail. And for the shoplifting, it'll be 12 months probation to serve 60 days, credit for time served 15 days. Again, you have 15 more days to serve at the jail. And then once you've completed the 15 days at the jail, oops, is there any confusion?
Looks like there is, Judge, if I could have a minute with my client.
Okay. Move. Mr. Shate, if your client would like to change his plea or whether he needs additional time, then I can take up another case while y'all are conferring.
All right. If you could move on to a different case, Judge, there seems to be confusion about the number of days and the credit, so I'll confer with them in the meantime.
He's got 15 days. He was booked in on December. Oh, there is this is very odd.
Right,
No, he was booked in on March 13th, 2025. And he's been in custody for 15 days. Let me see. This was from a December 17th offense. Yeah. He was released previously he was released on March 7, 2025. And then he was rearrested on March 13th, 2025. So it's 15 days on these 3 particular charges. He has been in custody for previous charges. There was another offense from February 18th, 2025, trespass and obstruction. And he was released on March 7th.
Okay, but I mean, his concern is that if he was in custody before March 7th, then
Those were for other incidences.
okay.
He took a plea on the prior instances before March 7th.
All right, so I don't have any internet connection here. My internet's very spotty, but did he bond?
Okay.
Did he bond out on these 3 counts?
No. Apparently, once he was released, there must have been an outstanding warrant from the December 17th incident at Walmart.
Right, but I mean, if he was, my point is that if he was in custody before March 7th on these cases, on this case, then I would think that counts as more credit for him. For the time that he was here before March 7th.
Hello, I'll be right with you. If you want to bring the files forward, yeah. Morning, Mr. Brown. Hang on, please. Mr. Chate, I am looking at the jailing screen. On these three charges from the December 17th incident in 2024, he has never been arrested on these three charges. He has been in jail for other charges.
I understand. Okay, so sorry about the confusion.
No, I'm just looking at the jailing screen. I am not fairly, I am absolutely satisfied that it would be 15 jail days attributed to these three charges. But if your client would not like to take the plea, I would totally understand. And we can reset this case for trial.
All right, and I'll explain to him then, Judge, and if you could give us a moment.
All right? Ladies and gentlemen, please hold. I just have a brief matter to address in court, in the physical courtroom. Please hold.
Just speak with their folders and I just get it in.
Thank you.
Thank you so much.
All right, resuming with our SAP calendar. Mr. Chate, we still have Mr. Gray seated next to you. How are we proceeding? Please unmute.
We're still going ahead with the original agreement.
You're going to proceed with the plea?
Yes.
Okay. As I was saying, with regards to, I think he's already pled guilty to these 3 charges, right?
Yes.
Okay. As I was saying, on count 3, for the court reporter, we're resuming with 25 CR 001-343Y. On count 3, it's going to be 12 months to serve 60 days, credit for time served 15 days. So he has 15 more days to serve at the Fulton County Jail. After he has completed the 15 days, and if there are no other cases holding him at the jail, he will then report to Fulton County Probation. He will report to 132 Mitchell Street on the first available Monday, Tuesday, or Thursday within 48 hours of being released from the jail or from any other holds that he may have. While on probation, he will complete 40 hours of voluntary community service at a minimum rate of 5 hours per month with any nonprofit agency that's not a church and not a school. He will enroll and complete a anti-theft class, and that must be done within the first 120 days while he's on probation. He's also to stay away from all Walmart stores, not just the one involved in this incident, but every single Walmart store on this planet. At all times, he will report to probation every month until the remainder of the 12 months are completed. He must be up to date with his fine at a minimum rate of $30 per month. He must be up to date with his probation fees, his community service, and completing the class. Thank you. Yes, Mr. Gray?
Can you give me an estimate on my release date, ma'am?
Well, today's the 27th. You have 15 days. So on the 3rd will be 7 days. On the 10th, it'll be 14 days. So I estimate it will be probably April 12th.
April 12th?
Yeah.
Okay.
That is if you have no other holds. I don't know if you have any other holds.
See any on my chart, ma'am?
I don't have your chart. I just have your jailing screen.
Perfect.
Medical, who do we have?
Number 42, she needs to speak with Tom White.
Mr. White, do you still need to speak to Miss Tumalapalli?
I do.
Right.
Right. My host is Miss Grace, Miss Hawkins.
You need me, Judge?
Oh, it's Miss Grace. Okay. Miss Grace, could you please place medical and Mr. White in a breakout, please?
Yes, ma'am.
All right. Courtroom 2, who do we have?
Position number 19 through 22, Mr. Johnson.
I'll check it out. All right.
And Miss Stewart, waiting patiently. Is that your client?
Yes, Judge.
All right. This is Bradley Johnson, case 23 CR 1892Y, accused of battery family violence from November 11th, 2022. He's got other matters on our calendar. Position 20 is case 23 CR 1895Y, accused of willful obstruction of a law enforcement officer from March 28th of 2023. He has 2 bench warrants, 25 FTA 576 and 25 FTA 582 for failure to appear in court on February 19th, 2025. Mr. Johnson, you've been advised of your right to remain silent, and your attorney is Ms. Sarah Stewart, who is on the Zoom. Do you see her?
Yes, ma'am.
All right. And how are we proceeding, Ms. Stewart?
Judge, the first thing we would like to do is ask the court to lift the bench warrants. If that doesn't happen, then I am awaiting an offer from the state, and I would discuss that with my client and be able to announce to the court after that discussion.
I'll allow you to have a discussion with Ms. Falk and the issue of the bench warrant. Why am I lifting it? He didn't show up in court.
Yes, Judge. Mr. Johnson was unhoused for a period of time at the time that notice was sent to him. It was not of any doing of his own. He was, as we would say, caught between a rock and a hard place, and that he had no valid address to provide the court to update it. You can see if you look on your docket, that is substantiated by the fact that that notice was returned to sender as undeliverable as the as the abode that Mr. Johnson was once staying in was empty at that point. Mr. Johnson has since rectified his situation. His mother is on the call. Mr. Johnson, if released, will have a solid, stable place to live with Ms. Johnson, who is on this Zoom and can tell the court about that. I have also submitted a letter from Mr. Johnson's employer. He now has steady employment at the Lazy Dog Restaurant, I believe in Alpharetta, where I submitted that to the court in the state. If I can share screen, if the court doesn't have it, I can pull it up for you as well. But she basically says that Mr. Johnson is the most important employee that she has on her staff, that he works diligently as a dishwasher, and that he would be very hard to replace if he were lost. So my argument to the court would be that we are doing nothing, that it works against the interests of the safety and the well-being of the community to keep Mr. Johnson incarcerated at this point, because the issues that led to his non-appearance have been rectified. I would also ask the court to consider the case of State v. Stinger, which can be found at 258 Georgia 605, where our Georgia Supreme Court has told us that the primary purpose of the bench warrant is to secure the presence of the defendant in court, and that once the defendant has appeared in court, the bench warrant is no longer necessary and should have no force or effect. It is simply a means to an end. And in the case at bar, Your Honor, that end has been achieved in that Mr. Johnson is here. The court has been assured of the reason for his prior failure to attend. The court has been assured and can be assured through sworn testimony of his mother that that situation is rectified, that that circumstance will not occur again. And through the letter of his employer showing his ties to the community. Additionally, I would say, Your Honor, that Mr. Johnson has a strong incentive to show up to court to defend himself against these charges. His family has come up with the resources to hire me, and not that having a paid attorney matters, but I do think that it shows a commitment to challenge the charges. It also gives the court an additional assurance that I will receive notice and Mr. Johnson and be in touch with Mr. Johnson and have a way to assure his attendance. And the final factor is that he has a very strong incentive to challenge the allegations in the, and I apologize if I get the numbers wrong, it is the domestic violence, family violence battery case, in that the alleged victim, and I know that the facts aren't necessarily all the way relevant. We're not looking to the truth of them, but having a strong defense can impact the AALA factors, and that we often hear the state say, well, the evidence is strong, and that gives them an incentive to wrong. The opposite is true here, in that the alleged victim is present on this Zoom court, hoping to speak to the prosecutor about her desire that the case not go forward, and about the fact that were she called to testify at trial, her testimony would be that the alleged battery never happened. So given all those factors, Judge, I think that the interests of justice are in favor of recalling those bench warrants, allowing Mr. Johnson out of jail so that he and I can work together to allow these cases to progress. And again, I don't have an offer. I believe that on the obstruction, I was emailing, and I do apologize to everyone. I was kind of late entered in the court into this case just this week. So I know Ms. Falk is very busy, but I was corresponding with her via email to try to get an offer, because it is possible we would be willing to resolve that obstruction case with a plea today, dependent on the offer.
Thank you.
Thank you.
Ms. Falk, if you could place your offer in the chat directly to Sarah Stewart, and then Ms. Stewart, you will speak to your client in courtroom 2. If you want to give your phone number in the chat to courtroom 2, I'm sure they'll be able to I don't know, is this a dated phrase, patch you through? But the other thing is, what does the Clayton County hold for?
Judge, the Clayton County hold is for a bench warrant. It is a drug possession, straight possession case.
All right, that's been, I don't know whether that was resolved, but he had it previously when he was arrested in Fulton County earlier this year. And now on this new arrest for the bench warrant, he's got another hold from Clayton County. So I'm perplexed. But in the meantime, I don't need to hear from the alleged victim. That's something that Ms. Falk and the victim can confer. So she's going to send you that information. The recommendation requires presently, if you all have children in the courtroom, please step outside now. If you all have children, please step out of the courtroom now. Do not bring children to these kind of proceedings. Thank you. And what's your name? Okay, I'll address you shortly. Thank you. I'm not inclined to lift the bench warrant given these current situations, but Ms. Falk, you're more than welcome to convey the information to Ms. Stewart. And then the alleged victim is Alexandria Johnson. I think I did see an Alexandria here on Zoom. Miss Alexandria, if you want to give your phone number to our prosecutor, Shelley Falk, you can put that in the chat directly to Ms. Falk. All right?
Yes, ma'am.
So Ms. Falk, plea offer to Ms. Stewart. Ms. Stewart, your phone number to courtroom 2. Alexandria, your phone number to Shelley Falk. I feel like I'm playing snakes and ladders over here. All right. Okay.
Your Honor, I did send the plea recommendation and I am reaching out to Ms. Johnson so she can send me her phone number.
Okay. And Alexandria as well, who is, yeah, Alexandria. Okay,
Right, Ms.
sounds
Johnson,
good.
Alexandria Johnson.
All right. Mr. Bradley Johnson, you would need to be seated back in the gallery until we revisit your case or cases. Thank you. All right, Ms. Stewart, if you'd like to mute the screen, please. Thank you. Medical and Mr. White, how are we proceeding?
Your Honor, this will be a negotiated plea.
All right. Can you, this was Ms. Tumalapalli, is that correct? Okay. Oh, I'm going to find out. Position number 42. This is April Tumalapalli, accused of reckless conduct from February 24th, 2025. Case number 25 CR 1146J. Ms. Tumalapalli, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Tom White will be representing you. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Ms. Falk, what's the recommendation?
Your Honor, if I may, what position is this?
42.
Thank you.
4-2.
I appreciate that. So the recommendation on the reckless conduct is 12 months or 48 days, credit for time served 24 days. That's going to be from March 4th, 2025 to March 27th, 2025. Balance probated in anti-theft course, 40 hours of community service, no further contact with Isaac Adebayo. Restitution to Isaac Adebayo remains open for 30 days. We would ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. We would like to sound for Mr. Isaac Adebayo. That's all for the state.
Mr. White, does your client accept the terms and do you so stipulate?
Yes, Judge.
All right. Ms. Tumalapalli, have you consumed any medicine or alcohol recently?
No, ma'am. No, ma'am. I've been in Grady. No, ma'am. Not like that. No, ma'am.
And have you understood what's going on with your case?
Yes, ma'am.
Are you
Yes.
satisfied with your attorney?
Yes.
And have you understood that if you decide to plead guilty to this charge, that you'll be on probation?
Yes, ma'am. I understand.
You'll need to do community service and an anti-theft class, and the case will remain open for the prosecutor to revisit the issue of how much you owe Mr. Adebayo.
Yes, ma'am.
So there's a chance that you may have to pay for damages.
We just, yeah, we discussed that, Judge.
All
Say
right, I just need it for my assurance before I proceed.
Yes,
So,
ma'am.
Ms. Tumalapalli, if you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to go back to court to face a judge or a jury, to challenge the evidence that'll be brought against you, to be able to confront your accuser, to be able to present your arguments and defenses, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of reckless conduct?
Guilty.
Your sentence is 12 months to serve 48 days, credit for time served 24 days. You'll be released within 24 hours if you have no other cases holding you, but you must report to Fulton County Probation on Monday, March 31st before 3 p.m. Yes,
Your Honor.
ma'am?
Your Honor, she does have a Coweta County hold.
Okay,
Court, in April on that. She missed court because she was here. So,
okay.
and we just asked the probation terminate upon completion.
Let me get back to the probation issue first. So in that case, Ms. Tumalapalli, you would need to first resolve your hold. Where was it again? Coweta County? Okay, in Coweta County. Once Coweta County releases you, then you must report to Fulton County Probation within 48 hours on the first available Monday, Tuesday, or Thursday. If you don't report, you'll be back in Fulton County Jail to serve out the rest of the 12 months. Do you understand?
Yes, ma'am.
Now, once you are with Fulton County Probation, you are required to complete an anti-theft class, and you must do so, enroll in that class within 60 days of being released. You're to complete 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. And you must do that at a minimum of 5 hours per month. You report to Fulton County every month, probation every month. While you're on probation, you're also to have no contact with Isaac Adebayo. You're to stay 200 yards away from him and not communicate with him at any time. Within 30 days of beginning your probation, the prosecutor has a right to contact you and your attorney and and tell you how much you owe Mr. Adebayo. They have only 30 days to do so. Do you understand?
Yes, ma'am.
So if you owe anything, that will be added to your probation conditions. Once you have completed all your conditions, which are your anti-theft class, your community service, any restitution if it's validly placed within 30 days, and your probation fees are up to date, your probation will be non-reporting. Thank you.
Thank you, Your Honor.
All right, courtroom 2.
Next, we have position number 12 and 13, Mr. Dixon.
12 and 13. All right, folks, please be patient. I am rocking 2 calendars, okay? This is Sir Quan Dixon, accused of criminal trespass causing damage to property from March 24th, 2023. And he's got a bench warrant, 25 FTA 584. Mr. Dixon, you've been accused of criminal trespass causing damage to property in case 23 CR 3131H, and you've got a bench warrant under 25 FTA 584. You've been advised of your rights, and your attorney is Mr. Chate. This is going to be a negotiated plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Mr. McDowell, if you are in court and you want to address the court, please remove your hat. Thank you. All right, Ms. Falk, what's the recommendation?
Mr. Dixon's case, position 12, 12 months served 30 days, credit for time served 15 days. That is from May 10th to May 11th, 2023, November 27th to December 1st, 2023, and March 24th, 2025 until, March 20th, 2025 until today. Balance probated, no further contact with Randall Dost. Stay away from 3760 Cedarhurst Way in Atlanta, 8 weeks of anger management and restitution. We are asking to remain open for 30 days for Mr. Randall Doss. Two of his tires were damaged as a result of this incident. We do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. We would at this time like to sound for Mr. Randall Doss.
Mr. Randall Doss, if you're on Zoom, please unmute and start your video. All right, Mr. Chate, does your client stipulate to the factual basis, venue and ID, and does he accept the terms?
He so stipulates, Judge. I just had a question about the restitution, and I didn't quite hear what the state said at the end.
So they are going to keep the case open within 30 days for Randall Doss to inform them of his damages, and that would be added to the probation terms, which he'll be required to pay.
And I did neglect to say, Your Honor, the state is null crossing position 13.
Yeah, the bench warrant will be null pros if he accepts the plea.
Can we go ahead? Okay. All right, then in that case, Judge, we'll go ahead and we'll also ask the court to consider community service instead of restitution, if that'd be possible. I'm not sure if this court considers restitution to be the same thing as a fine, but we'll make the request anyway.
The restitution can be anywhere from $0 to $100,000.
Okay.
I have no idea what Mr. Doss is going to say. So if he's not willing to move forward, we can reset this for Mr. Doss to give a figure, and then we can readdress the plea.
Just a moment, Your Honor.
I'm going to take a brief recess, please, just a few moments. Thank you. All right, going back to Mr. Chate, is your client now understand the restitution issue?
Yes, Judge, he understands he's going to go forward, and he also asks the court to consider putting him on non-reporting status once he completes the terms.
I don't think that should be a problem. Ms. Volk?
Not a problem, Your Honor.
Okay. Any ballpark on the possible restitution?
It was 2 tires, Your Honor, so I do not expect the amount will exceed $500. So if Your Honor wishes to cap it at 500, the state does not object.
Okay. Mr. Dixon, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to move forward with this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to go back to court to have a trial before a judge or a jury, to be able to confront your accuser, challenge the evidence brought against you in a court of law, and have the prosecutor prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
All right. There's a Brandon McDowell on screen. Are you in any way related to Mr. Dixon?
No, ma'am.
Why are you here?
I had missed court on the 14th.
Okay, all right, so you're on a bench warrant. Switch off your video and mute yourself. Thank you.
Okay.
Thank you. All right. Mr. Dixon, how do you plead to 1 count of criminal trespass causing damage to property?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. You will report once you don't have additional time. So within 24 hours, you should be released unless you have any other holds. Is that the situation?
He has a hold in Fayette County, Judge.
Okay. Then once you are released from your hold, then you need to report to Fulton County Probation within 48 hours. And you report on the first available Monday, Tuesday, or Thursday. Understood?
Yes, ma'am.
While you're on probation, you are to have no contact with Randall Dost. You are to stay away from 3760 Cedarhurst Way in Atlanta, Georgia. You are to enroll and complete 8 anger management classes, and you must enroll in those classes within 60 days of being released. You are also, the case will remain open for 30 days for Mr. Dost to advise the court and the prosecutor as to what the amount of restitution is, and the amount of restitution cannot exceed $500. So it has to be $500 or less. Do you understand, sir?
Yes, ma'am.
All right. And once the restitution is determined, and if it's within 30 days, that will be placed on probation as a condition of, it's one of the terms of probation. Once you've completed all the conditions, including restitution being paid, and you're up to date with your probation fees, then your probation may be non-reporting. Thank you. And the bench warrant will be dismissed. Thank you. There you go.
Your Honor, can we go to position number 35, Mr. Murphy?
35, yeah, Mr. White's client?
Can I represent myself? I don't have time to wait for the folks.
You're right.
All right, this is Malcolm Murphy, case number 25 CR 001367F. Mr. Murphy, you have been advised of your right to remain silent, and your attorney is presently Mr. Tom White. And how are we proceeding, Mr. White?
Your Honor, this is a negotiated plea.
All right. Mr. Murphy, is that correct? This is a negotiated plea?
Your Honor, if I may, I sent an email, and let me just pull up the date and time that I sent it. I sent an email to the court, including Your Honor, the PDs, and everyone involved in this case on a general email at 5:03 p.m. yesterday, letting them know that based on the injuries to the victim in this case, the state is revoking its offer effective immediately and will be reaching out to the DA's office and requesting an upgrade to aggravated battery. That's based on the information that we received from the victim, who stated he has sustained a fractured shoulder and had to get stitches in his head. So due to that, we immediately revoked the offer prior to acceptance and sent that email to all parties to make them aware.
Well, he accepted about 2 o'clock yesterday afternoon. So that wasn't prior to acceptance.
Well, the state was not notified that he had accepted the offer. We revoked
Please off the table, Mr.
acceptance of
White.
that offer.
Mr. White, the case is going to be reset to the next SAP depending on the decision by the DA's office. And if the DA declines, then I'm sure y'all can revisit this plea.
So we can't be heard?
That's what I'm just telling you. What would you like to
So
comment?
the answer is no, we can't be heard on.
No, I didn't say that, Mr. White. I'm just telling you what the court's position is. What would you like to tell me?
Before we're heard.
All right, I'll defer on this ruling until I hear from you.
Okay. Judge, I was at the jail yesterday, and this is how every SAP calendar goes. We do not announce that the plea has been accepted, usually until late in the afternoon, because by the time everybody gets to the jail and has interviewed everybody. But I saw him at about 2 o'clock. I have the jail slip here. He accepted the offer, and the state did not revoke the offer prior to acceptance. And they don't have to be notified of acceptance for it to be accepted. This is straight contract law. There was a meeting of the minds, an offer of acceptance, and he accepted it around 2 o'clock yesterday. I can't give you the exact time, but it was definitely before the email that went out around 5 o'clock. So we would ask that you hold the state to, and also a little background. Yesterday morning, I emailed Ms. Falk asking when we might expect offers. Got a response very soon afterwards saying, sorry, it's a little longer. We have a new staff. They have to make the offers, and those offers have to be reviewed by senior staff, in essence, is what they were saying. I'm paraphrasing. So the offer was made by someone, then senior staff looked at the offer and said, okay, that's good to go. And then we accepted the offer, and that's where we are here today. So we ask that you hold the state to their offer that was accepted by Mr. Murphy yesterday.
Okay. Ms. Falk?
Your Honor,
Do you have a binding contractual agreement to comply with this contract?
I would disagree because the acceptance was not actually communicated. I understand that he's saying that this is contract, but contract actually requires that acceptance be communicated. So without letting the state know, yes, we have accepted this, which the defense let us know at 12:28 in the morning this morning, we revoked our acceptance at 5 o'clock, 7 hours before we received notice that they were accepting the offer. So therefore, there is no meeting of the minds. The state revoked prior 7 hours before the defense communicated its acceptance.
If this was a civil court and we're dealing with a civil case, and I find that there is an absolute binding contract where there's acceptance, offer acceptance, and there's valid consideration, yeah, I would certainly agree with Mr. White's position. Except in a negotiated or non-negotiated plea, there is no agreement unless the court accepts it. So there's already a conditional agreement, and based on the representation, the base of the alleged injury sustained by the victim, the court is not going to accept any plea until the district attorney's office has had an opportunity to review this and to see whether there are valid grounds for felony charges. If they decline it, the case will be revisited with either the same plea offer or a different plea offer. So, Mr. White, would your client like to arraign the case today, or would you like to be reset for the SAP next April 3rd?
I'll need to speak with him.
All right. Courtroom 2, Mr. White would need to be contacted to speak to Mr. Murphy.
And Your Honor, I would just like to place this on the record just in case there's an issue later on. Under Anderson v. State, which is 352 Georgia Court of Appeals 275. It's an October 15th, 2019 case. A defendant's purported acceptance of any plea offer must be communicated to the prosecuting attorney to constitute acceptance prior to withdrawal. That cites a Sparks v. State case 232 Georgia Court of Appeals 179, which is a 1998 case.
And does it say that if it's accepted and communicated timely, that it's a binding contractual agreement that must be enforced by the court?
Well, in this case, since there was no communication, there is no acceptance, according to the Court of Appeals in this 2019 case.
All right. Thank you. All right, Courtroom 2, next case, please.
Judge, am I going to be able to speak with him?
Yeah, the jail should have your number, so they will communicate if the phone is free. Yeah. I'm not putting you in a breakout. So, Courtroom 2, I can take the next case.
Yo. I'm listening.
Your Honor, we can go to position number
No.
37 through 40, Mr. Saunders.
Is it gonna happen?
Did you say Saunders? Okay, position 3. And who represents Mr. Saunders? Mr. Bartel?
That is my case, yes. Good morning.
All right, good morning, sir. Let's see now. Saunders, okay. 37. I don't know why I can't get, okay, there we go. This is Donald Saunders. He's got 2 bench warrants, 25 FTA 589 and 590 for failure to appear in court on January 27th, 2025. He's got a misdemeanor matter, willful obstruction of an officer and fleeing or attempting to elude an officer from September 10th, 2022, case 23 CR 2637B. And he's got a theft by taking matter from September 13th, 2022. Under case 23 CR 2638B. Mr. Saunders, you have these 4 cases before us. You have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to you're an attorney. If you cannot afford one, Mr. Bartel will be representing you. Okay. Mr. Bartel, other than the bond hearing, are we entering a not guilty plea today?
Correct, Your Honor. He's entering not guilty pleas and we'll waive arraignment.
All right. So for positions 37 through 40, this is going to be a waiver of arraignment and further notice for trial. And go ahead.
Yes, Your Honor. We're not asking for a signature bond. We're just asking that the court consider, converting the cash bonds to a surety bond. It looks like there was a failure to appear on January 27th of this year in both cases. I did talk with Mr. Saunders about the circumstances surrounding that. He did advise me that shortly before that, his grandmother had passed away and his family was out of town for several weeks, dealing with her estate and her funeral arrangements. And while I advised him that, of course, the court date is legally binding, it is a very unusual circumstance in his life. And he wants the court to know that without those circumstances, he certainly would have appeared. It does appear that the notice was sent out, that he was living with his family at that time and told me that he was never given the notice. He does work full-time for Sims Construction Company. I'm advised that he has 2 children that live here in Atlanta and he is involved with their care. His mother and his extended family live here in Georgia, so he's got ties to the community. And it looks to me like on the FTAs, he's got a $2,000 cash bond on each. And we would just ask the court to consider converting that to $2,000 surety bond on each case. I think that would be enough to guarantee his appearance if he's able to make that bond.
Okay. Ms. Folk?
Your Honor, I hear what PD Bartels is saying. It sounds like the explanation amounts to notice was sent to the house, but he wasn't provided it from his family members, and that he had a funeral to go to, which I do empathize. I'm sorry.
Oh, God.
I'm sorry,
Not
Mr.
an
White.
excuse to-
Okay, sorry. Okay, go ahead.
That is not an excuse to miss court, unfortunately. And so the state would ask the bond to remain as set. The defendant currently is also on no bond on armed robbery, possession of a firearm, and gang charges that he is currently in jail on as well.
Mr. Bartel, what's the status of those felony matters?
All I know that it looks like there's a court date. I think May 1st is the prelim date. And
It's a what now?
I believe there's a court date on May 1st. I think it's a prelim date. I've seen quite a few armed robberies get reduced to something a lot less. So anything could happen. In terms of what's going to happen with the felony case, I can't predict.
Well,
Okay.
just to clarify, anything can usually happen. However, in this case, it has been indicted under 25 SC 00767. So the preliminary hearing would have no effect because it's already been to grand jury and indicted.
Okay. All right. I wasn't aware of that. Thank you.
Mr. Bartel, my concern is that I apologize and condolences for loss of family member, but this is not Mr. Saunders' first rodeo to a bench warrant. And since the incidences from 2022 involved in the cases with us, theft by taking and the other matter, he's been in jail for armed robbery, aggravated assault in February of 2023, where he posted a $43,000 bond. Then he came back to jail on November of 2023 for armed robbery and posted a $35,000 bond. And then he received a signature bond on May 24th, 2024. And then 2 months later, back in jail on armed robbery again, possession of a firearm, and participation in street gang activity. Then, of course, the bench warrants in the meantime. So, no, the bond's modification is denied. This cash bond is clearly appropriate for an individual who has a very high likelihood to reoffend, and based on this track record, reoffend quite dangerously. This case is further notice for trial. Thank you.
Very well. I will get the waivers to the clerk's office, Your Honor.
Thank you, Mr. Bartel.
Your
Your Honor, we can go back to Mr. Johnson. That is position number 19 through 22.
Thank you.
Take it roll.
All right, so on Bradley Johnson, oh, I'm so sorry, that was with Ms. Stewart, right?
Yes.
Okay, Mr. Johnson's already been advised of his rights, and this was the one where we were discussing lifting the bench warrants or considering a plea.
Yes, Judge.
I don't know what's behind door number 3, so Ms. Stewart, you let me know.
Ms. Falk has extended offers on Mr. Johnson's 2 pending cases, and I believe Ms. Falk, the 2 FTAs will be dismissed.
That is correct.
And Mr. Johnson has agreed to accept Ms. Falk's offer in those 2 cases.
All right. Mr. Johnson, then, for the court reporter, we are addressing case 23 CR 001-892Y and 23 CR 001-895Y, with the other 2 matters being the bench warrants. Mr. Johnson, you've been advised of your rights. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Sorry, Ms. Jordan, I didn't mean to make a mess over here. Sorry about that. Ms. Falk, what's the recommendation for the 2 cases?
Yes, Your Honor. The recommendation on the family violence battery has been modified per agreement with the defense. So there are some modifications to the original offer that I want to make note of for the court.
Okay.
The state's recommendation is 12 months served 24 days, credit for time served 12 days. That is from March 28th to March 30th of 2023 and March 19th, 2025 until today. Balance probated, no further violent contact with Alexandria Johnson, that is his sister. Stay away from 4971 Wawata Street in Atlanta. Family Violence Intervention Program and no firearms. Position number 20, the willful obstruction of law enforcement officer. There's been no change to that offer. That is 12 months served 24 days, credit for time served 12 days. The same dates apply, balance probated, and a $300 fine. We do ask the defense stipulate to venue, factual basis, and identification for both of these cases. We do agree on positions 20 and 21 that if this offer is accepted and the defendant is sentenced, that the state will tender null process on position 21 and 22. And Miss Alexandria Johnson is here. She would like to speak. I did not have an opportunity to speak with her, Your Honor, as I have been in court consistently. However, I will say that Ms. Johnson has indicated to Ms. Stewart that she did not wish to proceed. However, given the fact that there was a 911 call where she clearly stated her name, clearly stated the name of her brother, stated he hit her, and the officer saw swelling, we believe we would have enough evidence to move forward on this case, regardless of whether she wishes to go forward or not.
All right. Miss Alexandria Johnson, if you'd like to address the court, you would need to unmute and start your video. All right. Oh dear. All right, Miss Johnson, please raise your right hand. Do you other right hand?
My bad. I'm sorry.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Do you want to have do you want to have contact with Mr. Johnson?
Yes, that's my brother.
All right. And are you in fear of him?
No.
All right. So I can amend it to no violent contact while he's on probation. Would that be acceptable?
Yes.
Is there anything else you'd like to tell me?
That'll be all. Other than
all right. Thank you.
Okay.
You please mute your screen, or if you want to switch off your video, that's fine too. Ms. Stewart, does your client accept the terms then with the amendment of no violent contact? And do you stipulate to the factual basis, venue, and ID for these two cases?
Yes, Judge, just with the clarification that it's our understanding that those two probations will run concurrently.
That would be correct.
Yes, Judge, and the only thing we would ask that he be allowed to go non-reporting upon completion of all conditions of his probation.
Any objection, Ms. Falk? Are you on mute?
I am. The state would object based on the defendant's history, Your Honor.
I'll agree to non-reporting as long as all the conditions, his probation fees and so forth are up to date, and he doesn't get arrested while he's on active probation for anything else, including spitting on the sidewalk or jaywalking.
Thank you, Judge.
All right. Mr. Johnson.
May I be excused?
Oh, I haven't gone through the colloquy yet.
Oh, I'm sorry. I thought we had.
That's okay.
I jumped ahead.
All right. Mr. Johnson, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you, after your discussions with your attorney, are you prepared to enter a plea freely, willingly, and voluntarily?
Yes, ma'am.
Now, I'm sure your attorney has explained this to you. If you decide to enter a guilty plea to these charges, you would have to give up your constitutional right to a trial. You will not be going back to court. You will not face a judge or a jury. You will not confront your accusers, challenge the evidence brought against you, and the prosecutor won't have to prove any of these charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence from November 11th, 2022?
Guilty.
How do you plead to willful obstruction of a law enforcement officer from March 28th, 2023?
Guilty.
Your sentence for the battery, family violence is going to be 12 months to serve 24 days, credit for time served 12 days. If you have no other holds, you should be released within 24 hours. I think you have a Clayton County hold, so that's going to hold you. And then you will report to probation once you have resolved your Clayton County hold. And you must report to probation within 48 hours of being released, and you must report on the first available Monday, Tuesday, or Thursday. Understood?
Yes, ma'am.
While you're on probation, you are to have no further violent contact with Alexandria Johnson. I'm going to dispense with the stay away. You are to enroll in a domestic violence intervention program within 60 days of being on probation, and you must attend and complete all 26 classes at your expense, and make sure you submit your certificate of completion to your probation officer. At all times, you're not allowed to own, possess, or have any firearms. On the obstruction charge, again, you'll be on probation concurrent with the prior case, in which you will have an additional $300 fine, and you will pay that fine at a minimum rate of $30 per month. If you are up to date with you've completed your classes, you've completed payments of your fine, you have paid you have completed your, paid all your probation fees, then your probation will be non-reporting, also provided that you do not get arrested while you're on active probation. Do you understand?
Yes, ma'am.
Okay. And the 2 bench warrants will be dismissed. That concludes the case. Anything else, Ms. Stewart?
No, Judge, that's all
All
we
right.
have. Thank you.
Thank you. You're free to go. Please make sure that you email the plea paperwork to michael.jordan, yep, just like the basketball player, at fultoncountyga.gov.
Judge, I don't think I've received any plea paperwork.
Your Honor, I can send her, now that we have made the negotiation, I can send over the plea paperwork. I did ask Mr. Jordan to assist me, but if he is unable to, because I know we're both very busy, I'll send it over as soon as I can.
Okay. Ms. Stewart, if you can put your email in the chat to.
I have an email, Judge.
Oh, you have it? Okay.
Yeah, I think they both have it, Judge. Thank you. I appreciate it.
All right. Please make sure that it's completed and sent so that the jail records can contact Clayton County to pick him up and get the ball rolling on this.
Yes, Judge. I will do
All
that.
right. Thank you. You're free to go,
Thank
Ms.
you.
Stewart. Thank you. Courtroom 2, who do we have?
Position number 11, Mr. Daniel.
Number 4. Oh, 11, was it?
Yes, Judge.
Mr. Chate, this is position 11. Mr. Daniels, Josh Daniels, accused of theft by taking from February 27th, 2025, and case 25 CR 1357Y. Mr. Daniels, you've been advised of your rights. Your attorney is Mr. Chate, and this is going to be a plea. May I place you under oath? Other right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Folk,
Actually,
are you please unmute?
Thank you, Your Honor.
All right.
The state's recommendation is 12 months served, 30 days, credit for time served, 15 days. That's going to be from March 13th, 2025 until today. Balance probated, an anti-theft course, no further contact with Sachit Seth. Stay away from 301 10th Street Northwest in Atlanta, and 40 hours of community service. We did have an opportunity to speak with Mr. Seth's father, and he did state he agrees with the plea offer. He is here on the Zoom. However, the victim, Mr. Seth, is not present. We would like to sound for Mr. Seth's father, and do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
All right. Mr. Gaurav Seth, if you'd like to address the court, please unmute and, okay. Please raise your right hand, Mr. Seth. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Where is Sachit today?
Sachit is attending his class in Georgia Tech.
Okay, well, you didn't have to tell the whole world, but now we know you're a proud daddy. Okay. No, I'm being facetious. I'm so sorry. I just don't like to divulge a lot of victim information on, but these proceedings are live streamed. Okay, so Mr. Seth, what would you like to tell us? The recommendation is that Mr. Daniels should have no contact with him, stay away from 301 10th Street Northwest, and do 40 hours of community service as well as an anti-theft class.
I agree, Your Honor.
All right. In that case then, Mr. Seth, please mute your screen. Mr. Chate, do you stipulate to the factual basis, venue and ID, and does your client accept the terms?
I so stipulate, Your Honor, he accepts the terms and just ask that this go to non-reporting once he completes the requirements. And one additional detail, like he has another case here in Fulton County, so that might be keeping him. So we just ask for some time for him to report to probation.
Is it in state court or the other court?
I think it should be in the other court.
Okay. So he won't be able to report to probation and until he resolves the other felony matter. Would that be correct?
Yes.
Okay. Mr. Daniels, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood what's going on in this case in state court of Fulton County?
Yes.
And are you satisfied with your legal services?
Yes.
Are you prepared to enter this plea freely, willingly, and voluntarily?
Yes. Yes, Your Honor.
If you decide to do so, you would have to give up your right to a trial. You will not be able to come back to court and face a judge or jury in order to have a trial on the merits. You will not be able to challenge the evidence brought against you, confront your accuser. Your attorney won't be able to present your defenses and arguments in a court of law. And furthermore, the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Yes or no?
Yes.
How do you plead to one count of theft by taking?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. Once you have resolved any holds from any jurisdiction, including Fulton, you will report to probation within 48 hours on the first available Monday, Tuesday, or Thursday. While on probation, you will complete an anti-theft class, and you must enroll in that class within 60 days of being on probation. You will report to probation every month, and you're also required to do 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You're required to stay away from 301 10th Street in Northwest Atlanta, which is the incident location, and you're to have no further contact with Sachit Seth. Since we've been informed that he's a student at Georgia Tech, highly recommended that you stay away from Georgia Tech property unless you have any business with that university. Do you?
No, I just have to pick up my property.
You're allowed a one-time visit to the Georgia Tech Police Department, and you can go to the Georgia Tech Police Department with a police officer. So you may have to have APD escort you to the police department in order to retrieve your belongings. All right? You report to probation every month, and once you're done with your class and the 40 hours of community service, and you're up to date with your probation fees, your probation will be non-reporting. You're still required to stay away and have no contact. Thank you. Next case, please.
Next, Your Honor, we can go to position number 16, Mr. Floyd. McBride. Thank you.
Mr. Chate, have you spoken to Oscar Floyd? Is that correct? Is that position 16?
Judge, I just spoke with Mr. Floyd, and this is going to be a non-negotiated plea.
All right. There are two Floyds. I want to make sure we are discussing Oscar Floyd, right?
Yes, that's the one, Judge.
This is State versus Oscar Floyd, accused of theft by receiving stolen property from July 28th, 2023. Mr. Floyd, your case number is 25 CR 1364C. You have been advised of your rights and your attorney is Mr. Chate. This is going to be a non-negotiated plea hearing, which means that the prosecutor is going to give me one recommendation and then your attorney is going to give me an alternative recommendation. Keeping in mind that I have the right to disregard either one and have this case reset for trial. May I place you under oath for purposes of the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Thank you. Ms. Falk, what's the recommendation from the state?
Yes, Your Honor. The state's recommendation on this case is 12 months served 60 days, credit for time served 14 days. That is from March 14th, 2025 until today. Balance probated in anti-theft course. No further contact with LaTravis Burke. 40 hours community service. Stay away from 1105 Research Center Drive in Atlanta, and $1,500 restitution. This is based on a incident that occurred on July 28th, 2023, where the victim's Apple iPhone 14s was stolen. The iPhone was then delivered to a Walmart Echo ATM kiosk, which was located at 1105 Research Center Drive. The still images showed the defendant turning in his phone, the victim's phone, into the kiosk. And the defendant also was gracious enough to provide his identification card issued by the Florida DMV that showed him not only going into that kiosk, but receiving money from that kiosk. The reason the state's offer included a significant more jail time, not significant, more jail time than the time that the defendant has already served is because this defendant is a multi-state offender. He has offenses not only in Georgia, but also in Florida. So at this point, the defendant has, 14 cycles.
Oh, okay.
Your Honor?
I'm sorry. I was doing some math in my head for the numbers you gave me. Sorry. Go ahead.
14 cycles in Florida. The most recent conviction was April 1st of 2024, where the defendant received 24 months probation for grand theft auto. Prior to that, he had a resisting of an officer and battery conviction in 2022. That's May 31st of 2022, where he received 150 days in jail for that offense. Prior to that, he had let me just move up. He had a theft arrest that was abandoned in 2020. And prior to that, he had an auto theft in 2018. That case was also abandoned. A possession of cannabis in 2005, where he received 1 year probation. In Georgia, the defendant has, the defendant has 5 cycles, including this case. He has a 2021 arrest for criminal trespass, failure to appear, a conviction for possession of marijuana less than an ounce in 2021, where he received 17 days confinement. He also has, and that includes a theft by shoplifting in 2018, where he received first offender that was later sealed. He received 12 months probation, 20 hours community service, and a $567 fine. He also had a null prost case for family violence, battery, cruelty to children, and reckless conduct that occurred in 2017. So based on the fact this defendant has theft cases leading all the way up until 2024 for grand theft auto, and now this is a theft by receiving stolen property case, we did increase the jail time we were asking for. The defendant also has a fugitive from justice hold and a foreign hold from Lowndes County. So we would also like the court to take that into consideration. We would like to sound for Mr. LaTravis Burke.
Mr. Burke, if you're on Zoom, this would be the time to unmute and start your video. All right. Ms. Falk, I didn't get a chance to revisit the warrant, but did the victim get his phone back?
No, he did not.
Okay.
And that's why he was asking for the restitution.
Okay. Mr. Chate, what is the state's position, the defense position? Sorry.
The defense position, Your Honor, my client would like to ask the court to consider time served, given the fact that, he already has to pay the 1,500 restitution to do the anti-theft course and 40 hours of community service. These are difficult requirements for him. He also has holds in other jurisdictions, and that those are cases that he needs to deal with as well. And he also informed me that he's a single father of a 9-year-old son, so he wants to get these cases over the best that he can. And he's also interested in doing the reentry program, and he'd like to ask the court to consider that as well. So for those reasons, Your Honor, the defense asks the court to consider once again a time served with all the other conditions in place and reentry program for him.
This is Paul.
So he doesn't want to do the anti-theft class, is that correct?
Well, she's on the 11 o'clock calendar.
He says he'll do the anti-theft class.
Oh, okay, he'll do it. And will he do the 40 hours of community service?
Yes, Judge.
So what about the phone?
He will pay the restitution. All we're asking for is time served instead of 16 days.
Oh, okay. So when I did this case at first appearance, I specifically told the state that I would not consider just a 2-week or a 2-week jail sentence, given his record. So I'm wondering, why is he asking for time served? You have a very significant record. And the likelihood of restitution at this juncture, I mean, I have hope, but very little of it.
So, Your Honor, my client just wanted the court to consider time served.
No.
Okay.
Absolutely not. I think they're asking for less time than I would have imposed, but the state's asking for 16 more days. And then he'll need to report to his Lowndes County hold, and then he needs to be extradited on the fugitive hold. So the likelihood of him coming back to do probation in the near future is very, very small. I mean, he'll be out. He'll probably come back months down or years down the road, but I don't know what's going on.
I understand, Judge. Then I need a minute to confer with my client since the court is not accepting the.
I'm sorry?
I need time to confer with my client since the court is not.
I'm not. Thank you. And this one
All right, Judge. If it's not too late, then my client has to wait his appearance and enter a not guilty plea.
All right, this will be a not guilty plea. This is a waiver of arraignment, and further notice for trial will be a jail jury. Thank you.
And just for the record, since this defense has rejected the offer, the state revokes their offer.
Okay. Medical, who do we have, please?
This is Angela Morrow on the composite calendar, position 6.
Good morning.
Good morning. And Mr. Bartel, is this your client?
Yes, Your Honor. Hi, Ms. Mara. How are you?
Good morning.
Yes, Your Honor. As indicated, Ms. Mara is on the 11 a.m. calendar, but we did discuss her situation the last couple of calendars. I have spoken with Ms. Mara yesterday. I believe she is able to proceed with a plea. We have an offer from the state, which is basically a time served or suspended sentence stay away offer. She's been in for 45 days so far, so I think we're ready to go forward.
Are the state and the defense satisfied that Angela Mora is competent to proceed with the plea?
I am satisfied with the defense's contention that she is able to move forward.
Okay.
I am, Your Honor. Ms. Mara and I have talked about her case, and I've represented her a number of times in the past, so I believe so.
State versus Angela Morrow, accused of criminal trespass from February 11th of this year, case 25 CR 0000694F. Ms. Morrow, my name is Judge Lal. We are going to address your criminal case for trespass.
Yes, ma'am.
And first, I'd like to remind you that you have a right to remain silent. Anything you say in open court about the facts of your case, your statements can and will be used against you in the treatment of your case. So do not say anything unless I ask you a direct question, or if you have a question, you can ask that of your attorney. Do you understand?
Yes, ma'am.
Your attorney is Mr. Paul Bartel. You have a right to appointed counsel if you cannot afford your own attorney. Ms. Shelley Falk is going to speak first, and she is the prosecutor who is going to give us the recommendation, and then we will hear from your attorney. But for purposes of this hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation is 12 months served 90 days. Ms. Morrow has already served 45 days from February 11th, 2025 until today. So this will be time served. Balance suspended. Stay away from Grady Hospital. That's at 80 Jesse Hill Drive, unless she is there for medical treatment. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state. Just briefly, I will say that with the balance suspended plea, this will result in her not having to report to probation. Really, we just want her to stop going to Grady unless she's seeking medical treatment.
That is our understanding, Your Honor. We would just ask the court to accept the agreement, and I've talked with Ms. Morrow, and she understands that though she does go to Grady for medical treatment, once she's done, she understands she needs to leave when that's done.
Ms. Morrow, have you consumed any medicine or alcohol recently, like in the last 48 hours?
I've had my bipolar, my medicine.
Okay.
All.
And after consuming your medicine, are you still able to understand what we are all talking about?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, I am.
And has he spoken to you about what a plea hearing is?
Yes, yes.
If you decide to plead guilty to criminal trespass at Grady Hospital, you would have to give up your right to a trial in a court of law.
Yes, ma'am.
You will not come back to a courtroom. You will not face the folks charging you with this crime. You will not be able to challenge the evidence brought against you. And the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to one count of criminal trespass?
I plead guilty.
Your sentence is 12 months to serve 90 days, credit for time served 45 days, balance suspended.
Thank you.
You will be released within 24 hours, but you cannot return to Grady Hospital unless you have an appointment to see a healthcare provider or you are seeking emergency medical treatment.
Yes, ma'am.
If you are at Grady, you cannot have any violent contact, verbal or physical arguments with anyone at the hospital, including their staff.
Yes,
Understood?
Yes, ma'am.
If you engage in any kind of violent altercation while at Grady, you'll be back at the jail.
Yes, ma'am.
All right. Best of luck. Thank you.
Thank you.
Thank you, Your Honor. Good luck, Ms. Morrow.
Next, Your Honor, we have position number 43 and 44, Mr. Ware.
Oh, sorry. Could have done it then. Sorry about that. Did you say where? W-A-R-E?
Yes, Your Honor.
All right. Mr. Shate, I had a note here bonded out, but I guess not.
Yeah, that's what I heard too, Judge. It was surprised to me when I saw it.
Okay. All right. Christopher Patrick Ware, is accused of battery, family violence, and hindering a person from making an emergency phone call. Case number 23CR 7217F. This incident date appears to be August 3rd, 2023. Mr. Ware, you've been advised, oh, you've got a bench warrant as well on position 44, and that's 25 FTA 527, failure to appear in court on September 9th, 2024. Mr. Ware, you've been advised of your right to remain silent. Your attorney is Mr. Chate. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Thank you. You may put your hand up. Ms. Polk?
Yes, Your Honor. On position 43, the state's recommendation on position 1, which is hindering persons making an emergency telephone call, is 12 months concurrent to count 2. Position number 2, count 2, the battery, family violence, the state's recommendation is 12 months served, 120 days. Credit for time served, 20 days. That's from March 20th to March 23rd of 2023, and then March 27th until today. Balance probated. FVIP, 40 hours of community service. No further contact with Connie Wright. Stay away from the Motel 6 located at 3860 Flat Shoals Road in Union City. Position 44, the FTA, that will be null prost upon the court accepting the plea recommendation. We did have an opportunity to speak with Miss Connie Wright. She did that. She stated that they were homeless, but she is no longer homeless. She is now no longer residentially challenged. She stated there's not been any violence since this incident. She also agrees with the plea, but according to her, she does wish to continue contact. She did state she will be here on the Zoom, so we would like to sound for Miss Connie Wright at this time. The state does ask the defense to stipulate to venue factual basis on identification for the purposes of the plea. Nothing further for the state.
Ms. Connie Wright, if you'd like to add to the proceedings, you'll need to, okay. Would you like to say something?
Yes, I do.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
What would you like to add?
I do not want a stay away order. We do have a child together and we currently live together in Columbus, Ohio. We are still currently in a relationship and have agreed to family counseling since this situation has happened, which was long ago. And we would just like it to be resolved, and I would like for him to return home.
And Mr. Chate, your client understands that under this plea recommendation, he's got 40 more days to serve at the jail?
He understands, Your Honor.
All right. So Ms. Connie Wright, Mr. Ware is accepting a plea offer from the prosecution that requires him to stay an additional 40 days and at the Fulton County Jail, after which then he'll be placed on probation, and he'll be required to report to Fulton County Probation once a month, do the classes, and the question then becomes, does he have contact with you and the child in question? Has he, are you both married?
We're engaged to be married.
I see. Okay.
5-month-old child.
I'm sorry, what was that?
Just have a son, we have a 5-month-old, but a 6-month-old child. I have to say, would love to be on, like,
All right.
I take accountability and responsibility for everything that I have done, and I would like to resolve this and be over with it and done with it, move forward.
All right.
Your Honor, the state doesn't have any problem modifying that to no further violent contact.
All right. We can modify this to no further violent contact with Connie Wright. And I'll still require you to stay away from the Motel 6 because that's not where she's living now. So we're going to maintain that. I understand also that Mr. Ware has a fugitive hold or an outstanding warrant from Ohio.
No, that case was resolved, but I was in custody. I was extradited to Georgia
for court the day prior to my court date, so it was going to be dismissed at 12th. I was extradited here on 11th of was it, I believe, January. I was extradited here, drove here on the 11th of January, and my court date was on 12th of January. And I've been in jail since then, and that's why I was trying to see if I was able to get time served or a lesser sentence that would be able to be out.
Well, all I'm saying is that you're going to be here for, if you accept this offer, you're going to be in jail for 40 more days. This is a negotiated plea. You've accepted the terms. Now, if you have a bench warrant from Ohio, then I'm sure Mr. Chate can let that jurisdiction know what are the legitimate reasons of why they should lift the bench warrant. I don't have access to that particular case. All I know is that it's an outstanding warrant from February 2025. So if you want to speak with your attorney to discuss how you want to resolve this, or you want to move forward with the plea, otherwise this case will be reset for trial.
Your Honor, out of curiosity, I'm not seeing that on his jail screen. Is there something else that indicates that he is being held on an open Ohio bench warrant?
I'll let pretrial make that announcement. This is the message I got from pretrial.
Understood.
Ms. Washington?
Yes, Ms. Falk, I do see a hold for a domestic violence case from February 12th of 2025. And so that's what we were seeing as of the 19th.
Do you have the city or county in which it's?
Yes, Your Honor. It's Columbus, Ohio. It just says Columbus Police Department.
Okay. So it's a city police.
Yes.
Okay. So that's what we have.
Right. And I will just say the jail is just showing he's being held on the FTA. Obviously, they have the option to add something to that before he's released. I am just going by the jail screen.
Okay. Mr. Chate, would you need additional moments to speak to your client?
Yes, I
With
do.
your client, excuse me? Okay. All right, Ms. Wright, please mute your screen. And we can take the next case. While Mr. Chate is talking, I can take a couple of my bench warrants. Is Brandon McDowell is present? Mr. McDowell, are you still with us? There we go. All right. You're not
Yes, ma'am.
driving, right?
No, I'm at work, but I'm not driving.
Okay,
Someone
pull
else driving.
over. Okay, if you're not
Hold on, let me
driving,
out.
pull over.
Hold on, I gotta get out.
No, you don't have to come out. The vehicle has to be stationary.
Oh, I'm okay. I'm okay. I'm at work. but I'm
Okay, I think that's good if your plant worker is not there with you. This
Yes.
is Brandon John McDowell. He's got two
Yes.
open cases. You need to stop walking. He has two open cases with the State Court of Fulton County, 25 CR 900C, in which he's accused of simple battery, family violence, and count 2 is a battery of a particular nature, and the alleged incident is October 3rd, 2023. His second case is 25 CR 901C, in which he's accused of simple battery, family violence from May 28th, 2024. And with regards to both cases, he's got FTAs 25-001198 and 25-001197 FTA. These cases have been assigned. And if you just give me a moment.
They are in Judge Dixon's courtroom, Your Honor.
All right, and Mr. McDowell, you have a right to remain silent. Anything you say about the facts of these cases, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. Have you spoken to a public defense attorney?
No, ma'am.
All right, would you like an opportunity to speak to Mr. Tom White?
Yes.
All right, Ms. Grace, if you can place Mr. Tom White and Brandon McDowell in a breakout session, please. You'll see a message on your screen, Mr. McDowell, to join the breakout room.
Okay.
Yes, ma'am.
And I messaged Mr. McDowell about 40 minutes ago to give me a call, so.
Uh, I said something. I said, give you a call. Yes, I said.
That's fine. They're just going to put us into a breakout room now. We'll deal with it.
Okay.
All right. Mr. Shatay, are we still talking then? Okay. All right, we'll just be in a brief recess until Mr. Shatay is ready.
Your Honor, while we're waiting, I just wanted to make a brief announcement on position 15, D'Angelo Floyd.
All right, position 1-5, what's the announcement?
Your Honor, I sent over an order to Mr. Jordan yesterday. The DA's office did accept that case for transfer. The DA's office also accepted for transfer position 45, Brandon White. And
all these cases have bonds, right?
You mean the defendant had been
Yes.
given a bond?
Yes, they all should have bonds because these all should have been addressed they're on SAP.
They should, yes. I just need to double check that question. And then there was one more. Romano White, which I believe was an add-on case.
Yes.
On the add-on calendar, that has also been accepted. There was only a one position add-on case, and that case has been transferred as well. So Mr. Jordan has 3 orders for your signature on those 3 cases.
Honorable Judge, on the add-on calendar, about that, I think another public defender filed a motion to enforce the plea agreement on that. It should be an Odyssey. I have really bad internet connection. I can't verify that now, but I saw a motion and I wasn't able to open it before I lost connection. So
okay. When we get to Mr. Romano White, we will address that. But in the meantime, how are we doing on Mr. Ware?
we're going ahead with the negotiated plea, Judge.
You are moving forward?
Yes, so we're moving forward with this. We accept the terms and just ask that you go to non-reporting once he completes the requirements. And since we just heard that his primary residence is in Ohio, if it'd be possible to do the probation and FBIT by phone or virtually.
You know, I caught Columbus, but my mind automatically defaulted to Columbus, Georgia. Was it Columbus, Ohio?
Columbus, Ohio, Judge, yes.
Okay. Mr. Folk, I don't have a problem with telephone reporting. He'll be required to report attendance of his domestic violence classes that he's taking in Ohio and the community service that he'll be required to do a minimum of 5 hours per month. And once he completes all his conditions, I can place him on non-reporting status. Any objection?
No objection.
All right. Mr. Shatay, is that acceptable?
Yes, that's acceptable, Judge. And if he has holds in any other jurisdictions too, we just asked for you to allow time to deal with those other cases before he reports to probation.
Oh, yeah. He'll have to also address the warrant in Ohio. Okay. Mr. Ware, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And are you prepared to enter this plea freely, willingly, and knowingly?
Yes, ma'am.
You understand that one of the charges is battery family violence.
Yes, ma'am.
In Georgia, if you plead guilty to a charge of battery family violence, any subsequent arrest for a same or similar offense will be a felony charge. Have that been explained to you?
Right.
Yes?
Yes, ma'am.
Okay. If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not be going back to a court of law to face your accusers, challenge the evidence brought against you, be able to present your defense's arguments and mitigating factors to a judge or a jury. And also the state won't have to prove the charge against you or the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of hindering a person from making an emergency phone call and battery family violence from August 3rd, 2023?
Guilty.
Repeat.
Guilty.
For the hindering person making an emergency phone call, the sentence is 12 months to be served concurrently with count 2. For battery family violence, which is count 2, your sentence is 12 months to serve 120 days. Credit for time served 20 days. With the sheriff giving you a 2-for-1 ratio on jail time, you have 40 actual days left to serve on this sentence. Once you have completed this sentence, and if you are released, then you will make your first visit. Well, does he have any other holds besides Ohio?
No, Your Honor, I just reran it and I did not see any other holds.
Okay, so then he will make his first visit to Fulton County Probation in person within 48 hours of being released, and it must be done on a Monday, Tuesday, or Thursday. Do you understand, Mr. Ware?
No.
Your first visit must be in person with Fulton County Probation.
Yes,
And the probation office is located at 132 Mitchell Street in downtown Atlanta. After your first visit, then probation will be allowed via telephone. So all subsequent visits will be via telephone. And you will report from Columbus, Ohio. You must update the probation office and the court of your current mailing address in Columbus, Ohio in writing. Do you understand, sir?
Yes, ma'am.
You will enroll and complete a domestic violence intervention program. If you do the program in Ohio, make sure that before you start the classes, you present the identity, location, and type of program to your probation officer. It must be approved by your probation officer before you begin those classes. In Georgia, a similar program involves 26 weekly classes, so you must make sure that you have a similar program in Ohio. And you must attend and complete all those classes at your expense without missing or skipping any classes. You must begin those classes within 30 days of being released from any holds. You are to have no violent contact with Connie Wright, but you're required to stay away from the Motel 6 at 3860 Flat Shoals Road in Union City. You're also required to do 40 hours of community service with any nonprofit agency in Ohio, but it cannot be a church and it cannot be a school. You must do your community service at a minimum of 5 hours per month until all 40 hours are completed. Any questions?
Oh, yeah.
If you've done your community service, your domestic violence classes, and you're up to date with your probation fees, then your probation will be non-reporting. Thank you. Oh, the bench warrant is dismissed. Null prost.
Next, Your Honor, we can go to position 9 and 10, Mr. Clark. Second one.
I'm sorry, what position number was that?
9 and 10.
9 and 10, okay. Mr. Bartel, are we ready to proceed with your client?
We have an announcement to make, Your Honor. I spoke with Mr. Clark about his options. He wants to enter a not guilty plea, and we'll send over a waiver of arraignment.
All right. Mr. Clark, your case is going to be further notice for jail jury, and your attorney is entering a not guilty plea on your behalf for positions 9 and 10. Thank you.
Thank you, Your Honor. Good luck, sir.
Next, Your Honor, We're gonna go to position 7 and 8, Mr. Stevens.
Yeah, that's 7 and 8 on the 11 a.m.
Oh, I see. How are we proceeding, Mr. Bartel?
That's a negotiated plea, Your Honor. I've spoken with Mr. Stevens. I believe that he is able to proceed with the plea. He is currently a client with PAD, and Ms. Burgess, their social worker, has spoken with his case manager at PAD, Ms. Reese, and they've confirmed that they're willing to have him back. The offer is, I believe, a slight amount of extra time, but they're still willing to have him back. And I've communicated both offers to Mr. Stevens, and he indicates he wants to enter a plea on both cases. And that's number 7 and 8 on the 11.
Got it. So Rashad Stevens has two cases, 25 CR 1246F and 25 CR 1445F. Position 7 involves a criminal trespass from March 9th, 2025, and position 8 involves criminal trespass causing damage to property from March 8th, 2025. These are back-to-back trespass matters. Mr. Stevens, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Bartel is representing you. For purposes of this plea, may I place you under oath?
My right, you gotta be all right.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am. Yeah.
Thank you. Ms. Falk, what's the recommendation?
On position 7, Your Honor, the state's recommendation is 12 months served 45 days, credit for time served 18 days. That's from March 9th of 2025 until today. Balance probated. Stay away from 307 University Avenue Southwest. No further contact with Miss Dewana Coffin. We did have an opportunity to speak with Miss Coffin, and she had stated that the defendant has been to her home in the past, threatening to bust out her windows, and has busted out her windows in the past. They did have a previous case, 24 CR 000930J. She feels like the defendant is dangerous to her and does not want any contact with him and wants him to stay away from her residence, which is why we, although they are brother and sister, why we set those conditions. On position number 8, the criminal trespass and damage to property, the state's recommendation is 12 months or 60 days. Credit for time served 18 days. No further contact from Joanna Young. Stay away from 1463 Prior Road Southwest. $342 of restitution to Joanna Young. And I will put her address in the chat. That is a different address than the address I provided. The address I provided was the library where she worked. We did, I believe.
Go ahead, Ms. Falk.
Yes. We did have an opportunity also to speak to Miss Joanna Young. She stated she did not know the defendant. She was at the library where she was working, and he damaged her window, and she had to pay $342 to get that fixed. She does not want any contact with him and wants him to stay away from the location since that is where she works. So we do ask for those conditions as well. And the state asked the defense to stipulate to venue, factual basis, and identification for the purposes. We would like to sound for Miss Joanna Young and for Miss
Tiwana Coffin?
Coffin. Yes, Your Honor.
Ms. Tiwana Coffin, if you are present, please go ahead and unmute and start your video. Ms. Joshana Crew, if you are present, please unmute and start your video.
Good afternoon, Your Honor.
Good afternoon, Ms. Crew. If you'd like to raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
And which library is this?
You say which library? Or the defendant? My defendant's name is Lewis McCray.
Yes, Your Honor. She's actually here for a different case, not this case.
Okay, so you're here for Ms. Crew?
Well, he had his hearing, I think, at
Listen
9 a.m.
very
this
carefully. Which case are you here for?
He is here for Lewis McCray, Your Honor, position
Okay,
3. That defendant has already been sentenced on that case.
all right. Ms. Crew, you are addressing the wrong case. Could you please mute and switch off your video?
Yes, ma'am.
Thank you.
Thank you so much, Your Honor.
All right. Okay, so neither of the victims are present for Mr. Stevens' case.
Just to clarify, Ms. Falk, the address for Ms. Young, is that the one that you emailed me in Fairburn?
Yes.
Okay.
So that is her home address. Please don't provide that. But the address, the other address, this prior road address, is the library where she works. And she also wants to stay away from that area, from that location.
That was the location of the incident.
Correct.
Yeah, I just can't get chat because I don't have any internet, so I can't do that.
Totally understand.
Okay.
And I was sending that to Mr. Jordan, not to you,
Gotcha.
PD Cartels. Thank you.
Okay. Mr. Bartel, does your client accept the terms, understanding that he has additional time to serve on both cases?
He
And then
does
he'd be-
not- oh, I'm sorry. I'm
Go.
sorry. I didn't mean to interrupt.
No, that's okay. Understanding that he has additional time to serve in both cases, and then he'll be required to be on probation, to pay restitution, and stay away from 2 locations and 2 individuals.
That's correct, Your Honor. We did go over that. Just one question. It looks like Odyssey is showing that he was actually arrested on the 9th, but he indicates that it took quite a while for him to get out of intake. So the booking date is actually the 10th. And I know the court, I know that that's up to the sheriff's department, how many days he gets credit, but starting from the 9th, it looks like that should be 19 days. Do we know if they go from the arrest date or the booking date?
Shad Stevens. Okay, let me see.
That would be 19 days, and I would advise him that would mean 11 additional days.
I will just let everyone on the Zoom know that according to the jail time in the jail screen, they are giving him credit for 18 days. I understand the court can order however it wants, but that is how the jail is providing credit.
Okay, well, we would
Let
just
me
ask to get credit for
Feelings.
19 days, but I know it's ultimately up to the jail.
He was booked in on March 10th, 2025. He had first appearance either on that day or the next day. And he's been in custody now for 18 days for the 2 offenses from March 2025. What other times, where did he serve these additional days?
Well, it looks like he was arrested on the 9th, is where Odyssey is showing he was arrested on the 9th. So on his jail booking screen. It's the Jefferson's. Yes, sir. Do you have a phone number? No, sir. Okay. It's right there next to the truck. Yes, sir.
On the City of Atlanta arrest citation, it says that the offense occurred on March 9th, which is consistent with position number 7. I don't know, it doesn't show a time, but he was booked in at the jail on March 10th. So I don't know whether we passed the midnight hour, but I'm going to take it with March 10th, 18 days, not 19.
Okay, and we would just ask, given his circumstance, he's going to live in the, what's the name of the place? Oh, he's with PAD, Your Honor, so we would ask that the court waive the first 2 months of probation fees so he can get, hopefully get that restitution paid.
Yeah, I don't have a problem with that. I can waive his probation fees until the end of May.
Okay.
And then he'll need to start paying probation fees from June 1st onwards. And he'll be reporting to probation every month.
Would it go not reporting or, so report?
How many cycles does he have, Miss Washington?
If I may, Your Honor, he has 49 cycles.
Yeah, he'll be reporting every month.
I'm saying, I go on none. I'm saying you didn't get it clear, like you told me I go on none report. What's that?
Well, she's not gonna be involved.
You know what I'm saying? That's what I'm saying. How y'all?
Right. Mr. White, oh, sorry, Mr. Bartel, we ready to go?
I took the plea though. I'm out of federal courthouse back there though.
You'll have to report every month.
You know, and he brought me this. It's okay. It's okay.
I've advised him, Judge,
Federal
it's not up to
courthouse
me
back
what
there
the
report
state says.
All right.
He
Understand, Mr. Bartel, just one second, just one second, just one second, be quiet, just one second. Deputy, please place Mr. Stevens at the back of the room until he calms down. And if he speaks like that to his attorney again, we're gonna reset the case. If he's being disruptive, we can remove him. All right, Mr. Bartel, did you have any other cases or any other matters to address?
Yes, Your Honor.
We have position number 5 on the competency calendar, Mr. McBride.
This is Mr. McBride. That'll be a negotiated plea, Your Honor.
All right, thank you.
That's right.
This is Glenn Washington McBride, accused of simple battery against an officer, willful obstruction of an officer, giving false information to an officer, and an additional count of simple battery against a police officer. These are 4 misdemeanor charges stemming from March 12th, 2025. Case number 25 CR 1320H. Mr. McBride, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, Mr. Bartel will be representing you. Mr. Bartel, this is going to be a negotiated plea.
That's correct, Your Honor.
Mr. McBride, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Folk?
Yes, Your Honor. The state's recommendation on the simple battery against a police officer is 12 months served 90 days, credit for time served 15 days from March 13th, 2025 until today. Concurrent with count 2. Count 2 is 12 months served 90 days, credit for time served 15 days, a $300 fine, BHET, stay away from 4701 Fulton Industrial Boulevard, which is the entire strip mall. That is the willful obstruction. Count 3, giving false information, is going to be time served 30 days, credit for time served 15 days. And count 4, the simple battery against a police officer, is going to be 12 months served 90 days, credit for time served 15 days, concurrent with count 2. The defendant was just released in February with a criminal trespass from that same address. And this involved him striking law enforcement officers, which is the reason for the state's enhanced recommendation of jail time beyond the time he has already served. We would ask the defense stipulate to venue factual basis and identification for the purposes of the plea. That's all for the state.
We would so stipulate for plea purposes, Your Honor.
All right. Mr. McBride, have you consumed any medicine or alcohol recently?
Only my medication.
And after consuming it, are you still able to understand what's going on in your case?
Kind of, sort of.
All right, that would be difficult for me to proceed if it's just kind of, sort of. You have to understand what you are agreeing to. Do you have any questions to ask of your attorney?
No.
Do you understand what is going on in your case?
A little bit, yes, ma'am.
But Your Honor, if I could have some more time to talk to him.
Sure. Mm-hmm. Ms. Joshana Crew? Joshana Crew? Still there? No?
I'm here.
All right, Louis McCray, I don't want to misspeak, but he took a plea earlier this morning. And he's depending, I can't remember now, but he's going to be on probation. He's required to have no contact with you, to stay away from 3200 Cushman Circle, do anger management and community service.
Okay, so has his bond been set? I'm not sure if I'm asking the right question.
He's been sentenced. He'll be on probation. He's been convicted of the offense and he'll be on probation, and he's required to stay 200 yards away from you and not communicate with you in any way, form, or manner. If he attempts to communicate with you, you must immediately contact the Victim Advocate Office of the Solicitor General's Department.
Okay. Thank you so much, Your Honor. I wanted to get on the camera so you can actually see my face.
Understood. That's why I wanted you to make sure that you have the Victim Advocate's Office number. If he tries to communicate with you, please let us know.
Yes, I will. How much time, if you don't mind me asking, how much time we have on probation?
Well, it's going to be 11 and a half months.
Okay.
And Ms. Crew, this is the recommendation that Ms. Cheney spoke with you about yesterday.
Yes, ma'am.
Okay.
Okay. Everything is understood. Thank you all so much.
Thank you.
Have a great
You're free
day.
to go.
Okay, thank you. Bye-bye.
Bye-bye. Okay. Shall we presume, Mr. Bartel?
Yes, Your Honor. I did speak to Mr. McBride again. He did indicate that he wasn't sure about the court's question about his medication, but he said that his medication was not interfering with his ability to understand what's going on here.
Mr. McBride, do you understand what's going on here?
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
After speaking with your attorney, are you willing to plead guilty freely, willingly, and knowingly?
Yes.
So you understand that you will not have a trial. You will not go back to a courtroom to face your accuser, to challenge the evidence that the prosecutor will bring against you, to present your defenses and arguments, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 2 counts of simple battery against a police officer, willful obstruction of a law enforcement officer, and giving false information to a police officer?
Guilty.
For count 1, simple battery, your sentence is 12 months. Listen very carefully now. I don't want you to have any misunderstanding. Your sentence for count 1 is 12 months to serve 90 days, credit for time served 15 days. You have 30 more days to serve at the Fulton County Jail before you may be released. For count 2, willful obstruction of a law enforcement officer, it's going to be 12 months to serve 90 days, concurrent to credit for 15 days, balance probated. While you're on probation, you will pay a $300 fine. You will undergo a behavioral health evaluation and submit yourself to any treatment. And you are to stay away from the entire strip mall at 470 Fulton Industrial Boulevard, that entire strip mall. For count 3, giving false information, it will be time served to serve 30 days, credit for time served 15 days. And for count 4, simple battery, it will be 12 months, concurrent with count 1 to serve 90 days, credit for time served 15 days. You will pay the $300 fine at a minimum rate of $30 per month, and you will enroll in the behavioral health evaluation within 30 days of being released. You will report to probation every month until all probation time has been completed.
And Your Honor,
There was something else. Was it probation fees? Probation fees are waived up to end of May and then he will start paying probation fees from June 1st onwards. So he'll need to get a job so they can start paying probation fees
Thank
and
you.
his $300 fine.
Thank you, Judge.
All right, thank you.
I'll make sure you get it.
Mr. White and Mr. McDowell,
Yes, ma'am.
all right? All right, Mr. White, your client, courtroom 2, I'll be with you very shortly. Mr. White has got 2 pending bench warrants from Judge Dixon for failure to appear in court. How would you like to proceed?
Well, we're asking to set aside the bench warrants, Judge.
All right. Anything else?
Well, yes. I mean, first of all, the notice went to the wrong address. It was forwarded to his correct address, but he did not receive the notice until 3 days after the court date. He had tried to change his address. He thought he needed to do with the jail, not with the clerk's office. But as soon as he got the notice that he'd missed court, he went down to the courthouse and then they explained and he changed the address there. He hasn't missed court on this before, so we're asking that you just set aside the bench warrant. He is currently employed with Walsh Group. He's been there for some time now. He has children to support. He has significant ties to the community. So, and he hasn't missed court on this before, and he's immediately went to the courthouse and is now here.
Okay. Ms. Folk?
Your Honor, let me just take a look at one thing. I just want to see if the defendant had any previous bench warrants. If not, the state would not object.
You on the phone?
The state does not see any previous bench warrants for failure to appear. We do not object to a one-time lifting of this bench warrant and this being reset on the next calendar.
All right. Mr. White, I'll grant the motion to set aside the bench warrant in both cases. Please submit the requirements. Mr. McDowell, please understand that the court is only obligated to mail out the notices to the address that you provide. And if we don't have the correct address, it's incumbent upon you to come down to the clerk's office at the courthouse and provide us with an updated or change of address in writing as soon as possible. This is recorded as a first failure to appear that's been set aside. Any subsequent failure to appear may not get the same favorable treatment. All right, make sure you comply with the conditions of your bond and you are free to go.
All right, thank you, Your Honor.
Thank you, Your Honor.
Mm-hmm. All right, Mr. Bartel, who do we have in courtroom? I'm sorry, courtroom 2, who do we have?
This is Mr. Brown, Your Honor, number 3. It's a negotiated plea.
This is Mr. Emmanuel Brown on our SAP calendar. Case number 25CR 001315F. Mr. Brown's accused of loitering and prowling, misdemeanor possession of marijuana, and a PI charge. Incident date appears to be March 12th, 2025. Mr. Brown, you've been advised of your right to remain silent, and your attorney is Mr. Paul Bartel. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Folk?
Yes, Your Honor. On Mr. Brown's case, position count 1 will be 12 months served, 90 days, credit for time served, 15 days. That's going to be from March 13th, 2025 until today, and stay away from MARTA. Count 2, we are entering a null pros. Count 3 is 12 months served 90 days, credit for time served 15 days, balance probated, as well as stay away from MARTA and an SDET. The defendant currently is on open probation on 2 different cases, which we have listed on the plea recommendation form, and that is the reason for the state's recommendation over and above the 15 days he has already served. We would ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. That's all for the state.
We would so stipulate, Your Honor. I've spoken with Mr. Brown and advised him what his rights and his options are and the benefits of each option. He's indicated that he wants to go ahead and accept the state's recommendation.
Okay. Before I proceed with the plea, Mr. Brown, you understand that this will be a new probation case. This does not replace your other probation cases, and it won't run concurrent. This is a whole new probation case.
Yes, ma'am.
Okay. Mr. Brown, have you consumed any medicine or alcohol recently?
Oh, ma'am.
And you understand what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
So you understand that if you plead guilty to these 2 charges, counts 1 and 3, you will be giving up your right to a trial.
Yes,
You will
ma'am.
not go back to court to confront your accuser, challenge the evidence brought against you, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to count 1, loitering and prowling, and count 3, your PI charge?
Guilty.
The sentence for count 1 is 12 months to serve 90 days, credit for time served 15 days. Once you have completed the additional time, it's balance suspended, and you're to stay away from all MARTA property in accordance with all active suspensions against you. If you have a permanent suspension, you cannot return to any MARTA property, including their bus stations, their train stations, their buses and trains, and their offices. Understood? Count 2 is going to be null pros. Count 3, the sentence is 12 months to serve 90 days, credit for time served 15 days. Once you have served your additional jail time, you will report to Fulton County Probation within 48 hours of being released, and you must report on the first Monday, Tuesday, or Thursday of your release. Again, you will be on probation to enroll and complete a SD evaluation and submit yourself to all treatment that's required. You must enroll in the SD evaluation within 90 days of being released from jail and submit yourself to all treatment. Again, you have to stay away from all MARTA property in accordance with any active suspension, including if you have a permanent ban, which includes their stations, their offices, and their transportation vehicles. This is a whole new probation case. It is not in concurrent, nor is it replace any of your other active probation cases. Thank you.
Thank you. Appreciate you.
You have a good one, man.
You too.
Thank you, Your Honor.
All right. Courtroom 2, do we have any other cases?
Yes, give us a second, Your Honor.
All right. I was going to inquire about Mr. Bartel, the last person who I had on hold.
Mr. Stevens?
Yeah.
Give us a second.
Whenever you're ready, courtroom 2, no rush. Although Miss Falk looks like she's waiting for lunch, so.
That's not happening anytime soon. So I'm ready to keep going.
Okay.
Your Honor, I do have an announcement for Mr. Stevens. I think the best thing to do would be to reset him for SAP next week, since the offer involves additional time anyway.
All right. Oh, sorry. I need to get to the right calendar. This was on our 11 a.m. calendar. And position 7, 8, reset to SAP. SAP, right?
SAP, Your Honor, yes.
Okay.
I believe that's 4-3, Your Honor.
Y'all already got them folks on y'all.
Come on, you got a problem, nigga, take these handcuffs off, nigga, we can do, we gotta beat them. I ain't gonna beat what? Well, come on. Come on, I'm saying, like, don't be a cow, nigga, take the handcuffs out, they do, it's gonna be ridiculous.
Reset to SAP, April 3rd.
April 3rd, I've got that. I'm sorry, Your Honor, my attention is divided.
I understand. Thank you. Position 7 and 8 is reset to April 3rd, SAP at 9 a.m. All right, Mr. Bartel, if you and Ms. Kasha and Ms. Burgess would please hold, I just want to go over the calendar and then release anybody else who doesn't need to be here any longer. On the bench warrant calendar on McDowell, Mr. White will send me the proposed orders to set aside the bench warrants. On the add-on calendar, Ramona White, that is transferred to Superior Court. And Mr. Chate had something to address in that matter. Yes, sir.
Yeah, I can take care of it. Alex.
Whoever wants to take care of it, go ahead.
Actually, we're asking to reset that to the 4/18 calendar. For SAP, there is a pending motion filed in state court by an attorney from our office, Andrew Rogalowski, asking to enforce a plea deal in which the prosecutor that offered it is willing to get on the stand and say that he offered it and it was accepted. That was actually sent over here by them for us to handle the plea. And then Ms. Falk has then subsequently sent it up to Superior Court. So we're asking at least that reset it until the 18th, so that motion can be heard in Judge Richardson's court. They figure out a date to hear that.
All right, let me just go position add-on calendar. Ms. Falk, any comment?
Other than the state has a case that essentially says that state court cannot handle a case which they don't have jurisdiction over. And unfortunately for Mr. Romano White, this is his 4th theft by shoplifting. Actually, it's more than his 4th, which would make this recidivist. And therefore, this case is going to Superior Court. But we'll address that on the 18th.
Okay.
Just briefly,
go ahead.
The offer was accepted and made by the state. Because of that, like if you just go ahead and plea, we won't send it up. That was sort of part of the negotiation process from what I understand. Obviously, I wasn't the one negotiating it, but that's what I've been told. And the state prosecutor in the courtroom wants to enforce the deal as well.
All right. Mr. Jordan, do you still have the proposed order to transfer the case?
I do, Judge.
All right. We will not enter the order transferring the case at the present time, since there's a motion filed and that's going to be heard by Judge Dunaway. That's scheduled for, right now it's scheduled for jury trial on April 14th. So I'm just going to put a stay on the motion to transfer until Judge Dunaway addresses it. If y'all get an earlier hearing date, great. But right now it's scheduled for April 14th at 1 p.m. before, excuse me, not Judge Dunaway, Judge Richardson.
Yes, Your Honor.
Okay. All right. This and you said you want this reset to SAP on April 18th pending the outcome of the motion to enforce. Was that right, Mr. White?
Yes, Judge. I didn't know if there was a date scheduled yet for Judge Richardson to hear this. So if there is a date scheduled, then I don't think that's necessary that we put it back on this calendar. I just wanted a few days for it to get scheduled. But if you want to put it back in this calendar, I have no problem with that.
I'll reset it to April 17th at 9 a.m.
Okay, thank you, Judge.
And reset to SAP April 17th, pending, of course, on the outcome of the motion to enforce. And then if the motion to enforce is denied, then Judge Richardson can issue the transfer order and the case takes a trip to Superior Court.
Thank you, Judge.
All right, thank you. All right, reset to 417. Medical, who do we have?
David Dove, I'm not sure of the position number.
Repeat the last name again?
Dove, Dove.
Position 14, Judge.
Okay.
And it's a negotiated plea.
This is State versus David Wayne Dove, 25 CR 001358B. Mr. Dove is accused of criminal trespass from March 13th of this year. Mr. Dove, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Chate, who is sitting in courtroom 2. Do you see him?
Yes, ma'am.
For purposes of the plea, may I place you under oath, Mr. Dove? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Folk, what's the recommendation?
Yes, Your Honor. On Mr. Dove's case, the criminal trespass, the state's recommendation on that is going to be 12 months served 28 days, credit for time served 14 days. That's going to be from March 13th, 2025 until today. Balance suspended. Stay away from the Home Depot located at 1032 Research Center Drive in Atlanta, Georgia. We do ask the defense to stipulate to venue factual basis and ID for the purposes of the plea. That's all for the state.
Mr. Chate, do you so stipulate and does your client accept?
I so stipulate and my client accepts.
All right. Mr. Dove, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained that if you decide to accept this plea, you would have to give up your right to a trial? You will not be going back to court to confront your accuser, challenge the evidence brought against you, be able to present your arguments and defenses, and the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is going to be 12 months to serve 28 days, credit for time served 14 days, balance suspended. If you have no other holds, you will be released within 24 hours, but you cannot return to the Home Depot store at 1032 Research Center Drive. Most likely, you won't be able to return to any of the Home Depot stores since they tend to share your picture among all the different stores. So if they ask you to leave, do so immediately, otherwise you'll be arrested again.
Okay.
Thank you.
Thank you.
Okay, just to go over the calendar then, Ramona White on our add-on is reset to April 17th SAP calendar. On the main SAP calendar, position 1, Barnes was a plea. Position 2, Bates was a plea. Position 3, Brown was a plea. 4, Bussey was a plea. 5 and 6, Butler is a waiver of arraignment and further notice for jail jury. Position 7, Carter was a plea. 8 was null prost. 9, 10, that's Christopher Clark. Those were waiver of arraignments and further notice jail jury. 11, Daniels was a plea. 12, Dixon was a plea. 13 was null prost. 14 was just a plea. 15 is transferred to Superior Court. 16, Oscar Floyd is a waiver of arraignment and further notice for trial. 17, Gray was a plea. 18, Hernandez is going to be reset to April 3rd, SAP. 19, Johnson was a plea. 20, plea. 21 and 22 were null pros, same Bradley Johnson. 23, Javid Johnson was a plea. 24, Shanta Johnson. What are we doing? It's reset to April 10th. And this is for positions 24 and 25. 26, Ladrea was a plea. 27, Rodriguez Long was a plea. 28 was null prost. 29, Matthews was a plea. 30 was null prost. 31, Todd McClendon, I understand, has been released. Is that correct? All right, so that's further notice for trial. Same thing, position 32, release, further notice for trial. 33, McCray was a plea. 34, Vondre Minifield is a waiver and further notice for trial. Malcolm Murphy, 35, that is going to be a transfer to, no, hang on, what did we do there?
It was reset 1 week, Your Honor, so that I can talk to the DA's office to see if
That's
they'll
right.
accept the case.
Okay, so that's reset to April 3rd, pending a possible transfer. 36, Unique Patterson is reset 1 week, April 3rd, for a possible transfer. 37 and 38, Saunders, and 39, Saunders, and 40, Saunders. Those were waiver of arraignments and further notice jail jury. 41, Screen is going to be reset to April 10th. 42, Thamel Lapali is a plea. 43, Ware, that was a plea. And 44, Ware was null pros, that's the bench warrant. 45, Brandon White is transferred to Superior Court. And 46, Dennis Worthy, 46 and 47, those are waiver and further notice for trial. Any corrections to be done to the SAP calendar? No? Okay. Pre-trial, Ms. Washington, you are free to go. Victim advocate, you are free to go. Ms. Hawkins, you're free to go. Ms. Garrison, you're free to go. Probation, you are free to go. All right. Ms. Washington, you're, all right, take care, thank you. All right, other than that, we can stop our live stream. Mr. Bartel, you're going to be in courtroom too?
Sure, I'm here.